Yes.
Mine is item number 4.
Ah.
But I've been told that this is going to continue for some time. But second half, I've got appointment with the doctor. So if it's taken up as the second half, my lord, kindly excuse me. Because I was not there when your lordship has fixed it. That's why I came, my lord, today.
Item 4.
Yes, my lord. That is why I came today, my lord.
Who is for the other side?
I don't
Okay.
want to come today, my lord.
My lord, my lord, one mentioning, my lord, item 1 of the commercial list, my lord, is that contempt matter, my lord, where my lord had already dictated the order. It was 40 lakhs to be secured.
Ah.
My lord had dictated the order only for clarification on the register is being kept. I understand that this matter will go on, my lord. Will this, if this is not taken up in the first half, could I come at 2 p.m. just for passing of that order? Anytime subject to my lord's.
I am not giving any time because I
Fine.
don't know. If it may finish within 10 minutes, it may finish 10 days. I don't know.
Then we'll wait, my lord. We'll wait.
May I have your lordship's kind leave to...
Everybody should get a chance. Saturday, my lord, everybody should get a chance.
My lord, may I have your lordship's kind leave to mention a matter, my lord, without notice. This is that contempt matter, my lord, which happened yesterday. My lord, those people who
Yes,
had
yes,
come
yes.
from, my lord, Bihar.
Yes.
We are for, my lord, contender number 7 to 11.
11.
Now, my lord, clear, my lord, execution of deeds, multiple deeds in violation of an order of court, but they had no knowledge. So, my lord, yesterday, the vendors, my lord, we told them that the total amount is maybe 20 lakhs. You refund the amount to these poor people, and your lordship can cancel the conveyances. They were, my lord, initially agreeable yesterday. But I told them to come in the morning and to tell your lordship that this is what is the proposed plan of action. But the main contemptors thereafter, my lord, after, my lord, we left them, must have persuaded them. They have all gone back to Bihar, and now on phone they are saying, my lord, we want our land. So, my lord, we'll come back on the next
Okay, on
day.
the
And
next day you come, if they will
and
give
we'll
instruction, otherwise the court will take.
Yes, yes. But they are not liable for contempt in any way. I'll pay for costs, my lord, against the petitioners because seaward principle applies. They must have had notice and knowledge of the contempt.
Correct.
So, my lord, these people had no idea.
Okay, let us.
We'll come back on the next day.
You do one thing. Yes. Yeah. आएगा उनसे एक extra copy on the way. You have extra copy of the application?
Yes.
My file is on the way.
Yes. Hey, copy work.
All the parties are ready?
I don't know. I'm for 2 and 3. And I'm for 5. তো বলে দিই কনসেন্ট অর্ডার থেকে দেখেছি দর্শক দেখেছি
I think this is a mark copy. Your mark copy you are given, Mr.
কি দাগ দেওয়া আছে?
No, they have taken note on that.
They tear out the first page.
Okay, no, 10 minutes in my file.
Yes. Lord, we have no problem. Lord, the advantage now, my lord, is that the minutes, my lord, are before your lordship. Number 1, minutes of the executive committee meeting. And we also have, my lord, the affidavit in opposition. So, my lord, the spectrum, my lord, of the final hearing has changed. Lord, knowing constraints of time, and, my lord, the fact that because of that detailed hearing, my lord, your lordship would have a fair recollection of the matter. I'm not going into the basic facts. Lord, I'll just, my lord, indicate this. There was, my lord, a circular which was, my lord, sent by the plaintiff to all members. After which, the secretary of the club, who's, my lord, an employee, writes to him saying that have you
made a confirmation?
Then, my lord, he is told to appear before the members' relationship committee. He appears. We, my lord, video recording is there. We transcribed it. That's before your lordship. After that, my lord, are a series of letters exchanged emails, my lord, exchanged between the plaintiff and, my lord, the club, ultimately culminating in the order of suspension. Sum and substance of this, my lord, is now, A, my lord, we say that, my lord, please give us copies of the minutes. Club says that the video recording as you wanted is provided to you. Those are the minutes. We also issue a very important letter, my lord, on 27th, my lord, of January, where, my lord, we 29th, after the 27th meeting, where we will not indicate what had transpired at the meeting of the committee. This is committee meeting is 27th, 29th, we give an email, what has transpired at the committee meeting, and the order comes. This is, my lord, the background. Now, my lord, I'll take, my lord, I'll just indicate the points now, my lord, one by one, and show your lordship the documents, and try and, my lord, be as quick as possible. First, my lord, is doctrine of, my lord, proportionality. তুমি এখন শান্ত হয়ে বসো। My lord, your lordship may also at some point of time want to see the minutes of the executive committee. My lord, the registrar of this court, my lord, has them. If your lordship, my lord, ask them to be sent given to your lordship.
Mangalo.
Their stand is, I don't have a right to see the minutes. My lord, I don't want to waste any time today. If your lordship sees it, that's good enough for me.
Mangalo.
My lord, first is, my lord, proportionality. What am I, my lord, being castigated for?
Yes.
My lord, please see. কথাটা বলো। Circular. 254. My lord, please see 254. হ্যাঁ, এই তো বেরিয়েছে। এটা উড়ে গেল সকালের নোট।
That is the main circular.
Yes, the one which I sent.
Correct.
Proportionality. First point, my lord, is what did I say? What did I say thereafter? And what is the punishment?
Yes.
Because suspension, my lord, is a punishment.
Yes.
As per, my lord, club laws, my lord, suspension is a punishment. My lord, certain issues I have already lost once. My lord, I am not revisiting those at all. My lord, because I know it will take a lot of time for me to try to, my lord, persuade your lordship, and chances of success are, my lord, much lesser, because your lordship has already once considered.
Okay.
So I'm only on additional issues now. And to the extent, my lord, the affidavit changes, my lord, the scope of adjudication. My lord, please see what I have said. I do hope this letter finds you in the best of spirits and health. We are all valued and regular members of our esteemed club. I am writing to invite you to participate in the upcoming annual general meeting AGM scheduled to be held on 28th September 2024 at 11 a.m. at the club.
Yes.
My lord, please, my lord, see, my lord, the first thing.
Yes.
What am I saying? I'm asking you, I'm inviting you as a member, to all members of the club, I'm inviting you to participate in the AGM. It has recently come to light that there have been significant financial irregularities within the club. My lord, significant financial irregularities are, my lord, the three important words which require immediate attention. My lord, what am I saying? Which required your attention and collective discussion in an open forum.
Yes.
These irregularities raise concerns about the financial management and transparency of our club, and it is imperative that we address these issues together to ensure the integrity and sustainability of our club's financial affairs. To summarize some of them, 8.25 crores spent on building furniture, fixture, equipment in one financial year, investment coming down by 2.5 crores, gross irregularities in figures which were shown last year and brought forward this year. Then, no explanation or schedule provided to show the applicability of huge money spent. No prior intimation or permission sought from members before venturing to spend over 8 crores in a financial year. Whether 3 quotations were invited before allotting work. During the AGM, and this is what I'm telling the members. During the AGM, we will try to provide a detailed overview of the financial irregularities that have been identified, discuss their potential impact on the club, and collectively work towards finding solutions to rectify these issues. Your insights, input, and participation in this meeting are crucial, and as we navigate through these challenges and strive to uphold the value of transparency, accountability, and good governance within our club. I urge you to mark your calendars and make every effort to attend the AGM to contribute to this important discussion and decision-making process. So, my lord, the point number 1, the impetus is not to, my lord, castigate somebody finally and said remove him, get rid of him, etc. The impetus is to highlight certain things which I feel and to come to the club at the AGM for discussion. In a democracy, you do not stultify discussion. Number 1. Now, my lord, please see my client's attitude.
So as per your submission, this letter is nothing only for the purpose of to see what are the conduct of the club with
Conduct
regard to the investment
on the
made
balance sheet.
on the balance.
On the balance sheet. So,
What-
number 1, I've given specific instances, 8.5 crores spent,
Correct.
depletion, mismatch in figures, gross.
These are
And-
the 6 points you have raised.
Yes, and come to the club. Now, my lord, I'm not saying that, my committee, our committee is bad, they are thieves, get rid of them. I'm saying come for the AGM because it's necessary to discuss this in a collective forum. This is, my lord, democracy. This is what we, my lord, celebrate. Now, my lord, please see my client's attitude. There's only one reflection. That is at page 274. After the committee meeting, where, my lord, I was suspended, I, my lord, wrote a letter to them indicating what had happened at the meeting. This is before the order came. Please, my lord, have a look at
Page 270.
274.
Yes.
My lord, please see 275, paragraph 5. This is written to the entire committee
Yes.
and the past presidents present. 275. This is the main committee meeting. In the meeting held on 27 January 2025, both the members of the committee and I stuck to our points of view, where the committee told me that the videograph of the meeting held on 8 November 25 be treated as the minutes of the meeting, and I kept on insisting that the videograph can never be treated as the minutes of the meeting, and the written minutes of the meeting be forwarded to me as promised in the MRC meeting dated 8 November 24 for me to take further steps. And this, my lord, has been correctly, my lord, captured by the committee. Now, my lord, please see the next 4 paragraphs. When this interaction was underway, Mr. Nitin Dani, a former president, intervened and asked me a question that whether my WhatsApp message, which was circulated to the members of the club prior to the AGM, which included the word significant financial irregularities, was meant that the committee members have been siphoning the funds. To this question, this is at the committee meeting on 27th.
Correct.
To this question, I immediately replied that I never meant that, and I categorically stated that the irregularities were in the manner in which the accounts of the club are maintained and audited, and that in the balance sheet for the year ended 23-24, more than 20 corrections have been made for the accounts which were already approved and passed a year back for the year ended 22-23. Such irregularities was sought to be highlighted in the AGM of the club held on 28 September 24. I further stated in the said AGM, I vehemently proposed that the auditor be changed, and since the turnover of the club is now in crores, the best possible auditors be appointed so that such irregularities do not crop up again. The present members of the committee can check the minutes of the last AGM. This is not the last AGM where I had proposed the same. Further, I had also proposed that in case the committee has misunderstood the meaning of financial irregularity, I can again write to all the members stating what exactly I meant by such statement. That I don't mean any disrespect to you. I don't mean you're stealing. I'm sorry.
This proposal was not.
This proposal was not accepted by the committee, and the committee only wanted answers in writing without providing me the written minutes of the meeting, which was promised in the MRC meeting held on 8 November 24. During such argument, one committee member asserted that the term financial irregularity meant that it was the members of the committee who have committed financial burglary, to which I reiterated that I had casted no aspersion of financial burglary on any of the members of the committee of the preceding year. It was purely meant irregularity in the manner which the accounts of our club was audited by the then chartered accountant appointed by the club. The present committee should appreciate that I, along with other members, not raised pertinent financial questions for the year 22-23. This process of irregularity would not have been undertaken, which according to Mr. Rishi Bajoria was reclassification. Rather than putting a former precedent to scrutiny, the present committee ought to have undertaken a forensic audit from a renowned chartered accountant, as it is evident from the annual report there are certain errors in the same. Point I want to make, my lord, is point number 1. In my circular to the members, I have said serious financial irregularities, but I have pointed out cogent issues in the accounts, and I have also wanted, my lord, a discussion at the AGM. The letter is not for anything else but for the purpose of pointing out to members, this is the problem, and come to the AGM to discuss. That is, my lord, democracy. That is, my lord, everywhere, my lord, democracy, my lord, is celebrated.
Yes.
Not, my lord, suppressed in this way. Number 2, in the meeting, I'm sorry, my lord.
Yes.
I want your lordship to write it down.
Yes.
Second, my lord, in the meeting, where, my lord, the suspension is done, in that meeting, I clarified. In that meeting, my lord, I said, if required, if you feel that I have belittled you, made accusations, I'll issue a similar circular clarifying I never meant that you are doing burglary. Now, my lord, I'm not saying, my lord, that this itself is enough. What I'm saying is that, is this considered in the order? There is no response to this email by the committee saying that this did not happen.
Yes.
Now, if on the 27th, my lord, in the meeting,
Yes.
I have taken a stand that I did not mean burglary, I did not mean you disrespect, and I would circulate. Mr. Shah wants to.
I don't want to address your lordship, my lord. 11:30 is the meeting. At least permit us to go and tell them that the matters being heard and they should adjourn the meeting. They're holding a meeting to expel me at 11:30 today. But so at least permit me to go and tell them that the matters being heard.
Lord, Mr. Shah is a senior member of the club. Lord, your lordship recalls, Lord, there are 3 members whom Lord, nominee members at the special board. He told me, Lord, to request your lordship to permit him to go and tell them, because he is attending the meeting now as a senior member of the club, to tell them that court is hearing a matter. So at least adjourn the meeting for some time till court concludes.
Now, what I propose,
Yes, my lord.
subject to by the other the club also, as per your request and as per the division bench, the special meeting is to be conducted today. So it is not good for this court to restrain the
Yes.
member to conduct any meeting. Let the conduct, but any decision, if it is going against the plaintiff, please to stay their hand.
I'm so grateful, Manoj. That should
stay
suffice.
their hand till let this application.
I'm so
be
grateful,
disposed.
Manoj. That should suffice.
It is my view.
Yes,
Because I am not.
Absolutely, and we will do that.
You should wait.
We will go and participate
But
now.
if it is going against, if it is not against, again normal, you can take the resolution. If it is going against the petitioner, please stay your hand till the disposal, till
I'm
the
so
order is
grateful, Manoj.
passed.
That
in
should
the-
suffice.
It is my view.
My lord, the senior most president, my lord, is Mr. N.G. Khaitan. He is also going. Mr. Shah is also a senior member. He is also going. The bar will support, my lord, our colleague against this sort of witch hunting. My lord, everybody is going.
You conduct a meeting, no problem. But if this you are
Correct,
going
Manoj.
to,
The court cannot be overreached.
yes, if
That's
you are
all.
going to take instruction, otherwise I will pass immediately. I pass an order, so it can be communicated. If you are
Yes,
if you
yes,
are facing
no,
any
So that I
difficulties
can
on that,
myself
you
communicate.
take. If you say that and it's okay. If say that now it is required, then immediately I'll pass a 2-line order. Then it will be communicated.
I will take the instruction. Neat.
ये दे दो आ गया
So, my lord,
you take back your thank you for
Apology, my lord, for the mask.
no
my lord, on 27th at the meeting,
yes
this crucial explanation which is given and the offer to, my lord, circulate another, my lord, in the event we have offended you, to circulate clarifying. My lord, question now is it considered in the minutes of the executive committee meeting on the 27th? I would never know, but your lordship would. Lord, please see the minutes once.
ये अंदर खोलो उसको
No, I will continue till 4:30. No, I will finish so that you can argue. No, we will not agree to anything today.
है ना 1 1 2 1 3 GA का अलग 1 2 तक है तीसरा का है
But you will go back. Speciality nagi.
ये
तो उसी आगे का साथ जुदी
minutes dated
So, my lord, this would be 27th.
27th September
My lord, January. Date bolo na. What?
27th.
January, na? January 25.
Just sharing.
I will put your phone on the ground, put my key and crush it. You concentrate here. Is this explanation considered is the, my lord, issue? And is the offer
Or I'll come back in 5 minutes. Come back in 5 minutes. Chaudhary will argue for some.
Yes, yes.
You also argue till 4:30.
No. I have to get you to give an answer. When I was young, I used to watch Mr. Arnold Schwarzenegger in the Terminator. Today, Mr. Bhattacharya is here and he is the releaser.
With Nirmal look.
Akin to the Terminator.
You got it self-released. You got it released from the Pathat stage from my lord. You forget it.
My lord doesn't take up the
Whatever it is, you got it released on oral mention.
Leave. What has happened? This court is not going.
That was he.
Lordship every day, Milord, that doesn't
make sense. He, is known as the Prabhu, the god of the bar.
Mr. Bhattacharya, you should be proud of him.
I
have urged, my lord. I had urged, my lord, that my lord, small amount of tax be collected from all of us. Because, my lord, if one day Mr. Bhattacharya does not come, the bar does not know what to do with its time. So, my lord, the amount of, my lord.
Aniruddha Chatterjee and I, will be very, very, disheartened if he doesn't come to court for a few days. May I just request, because matter is getting very heavy, I want to make it light. May I just request for the live streaming to be stopped for 1 minute?
ये बंद कर दो जरा.
You a lesson.
You should. It was completely unforgivable. You should. I mean, assisting.
One was enough. Joy gives to both. Yes, my lord. Let him finish. We will not publish the decision either. The matter gets over.
Please.
But let him finish today.
I will finish in little time.
In that case, would it be a lordship pleasure to pass a two-line
No,
order?
please don't pass any order because
What is the situation now? That's why stated.
So, my lord, we'll communicate, my lord, that this is
Communicate.
what Mr. Abhijit Mitra has said.
Communicate.
we'll not publish the decision.
Not. Yes.
If there is, consideration of, these factors, then, your lordship would have the opportunity to see whether the consideration is perverse or not. If there is no consideration,
When this letter was issued?
29th
29th
of January. And this records what has happened in the meeting. If, this is not considered, then it's, extremely perverse.
No, it is given on
29th.
29th and meeting.
This is about the 27th meeting.
Ah.
Where, what is happening? 27th, you're meeting to suspend me. and based on what transpires on the 27th meeting,
Hmm.
decision is adopted in the 27th meeting to suspend.
Correct.
Decision, my lord, is communicated by a document which bears no reflection of, my lord, these events. My lord, that order comes to me on 30th.
30th
30th.
January.
On 29th, before the order comes,
Hmm.
I, my lord, write an email recording what has happened on the 29th at the meeting.
Correct.
So in the 27th meeting, when you're suspending me based on that circular,
Correct.
I'm going and saying that, look, I did not mean any disrespect to you.
So that's where that has been made on 29th,
Yes,
but the meeting was held on 27th.
yes. So this is about the, I'm sorry, Millard, my mistake. I should have read the first paragraph of the letter.
Hmm.
Millard, please come to page 346.
Correct.
Yes, I'm sorry, Millard. 274.
274.
274.
Correct.
This is to put on record
Hmm.
that by an
Email
email
channel.
dated such and such, the committee had requested me to appear on at 17:30 on 27th.
Hmm.
And upon my request, President allowed one former President, Mr. Nitin Dani, to accompany me.
Correct.
No sooner that the meeting started, the President asked me whether answers as sought for MRC, which was forwarded, ready. And then, my lord, so this is what had happened at the meeting. Now, this is paragraph 5, paragraph 6, 5, 6, 7, and 8
Hmm.
are all, my lord, recordings of what happened in the 27th meeting. So the statement made by me that I meant you no disrespect is at the suspension hearing. So, my lord, at the hearing, I go and I tell them that there is, my lord, no disrespect meant. And if you feel that this is something which has denigrated you, I will issue a circular again clarifying the position at the hearing on 27th. Now, if when I make these, but this is part of the hearing on the 27th, which I record in my 29th email.
Correct.
So, my lord, therefore, if, my lord, at a hearing, like these submissions which I am making, my lord, before your lordship today, it's akin to this. It's akin to this point which I am taking. And then, my lord, 2 days later, I record that I went at the hearing and said this. And then the order comes, the order doesn't have a word of consideration of this, which is why I wanted to see whether the minutes record this or not.
No, minutes. That's why I'm asking, because this you have given on 1st of September, 29th of January 2025.
Yes.
Meeting was held on
27th.
And on 29th of January, you are telling that you had.
I had said this on the
said this on
27th. Then and nobody has disputed it ever.
This is not disputed.
Not disputed.
This letter is
There
not-
is no response to this email, my lord. I'll just check once
What
more.
is what is the reply to this annexer annexer II?
My lord, I'll just show you.
In which paragraph you mentioned the
Yes,
annexer
I'll
II?
just show your lordship. The next date, my lord, is 4th December 2024. 30th, my lord, order comes.
27. This they have taken the decision.
Yes.
Then 30th this was communicated to you.
Communicated. By 29th, I record that this is what happened in the meeting.
Correct.
And my lord, there is no response to this email of 29th. Sure. Yes. 30th, the suspension order.
30th suspension order. 27 they have taken decision. 30th it was communicated to you. 29th you have given this.
Yes,
And
I've given this recording what has happened, my lord, in the meeting. So, my lord, my first point
What is the reply to this annexer II in
no,
their
no reply.
affidavit?
No affidavit.
Which paragraph you have described II?
My lord, please first see page 19 of the affidavit.
Your affidavit.
Yes. Yeah, I'm sorry, my lord, affidavit in opposition. এটা আইআইটা কোথায় ডিল করেছি বডিতে বার করো হ্যাঁ Miller, how they deal with this letter? Miller, they've given a list of events at the beginning.
Page.
Miller, page 19.
Yes.
They've made a list of dates of what had happened.
Correct.
What is their narration?
Yes.
Plaintiff issued a reply to the president and committee members on his refusal to not give a written reply
Yes.
to the 3-point clarification questions.
Yes.
The plaintiff reiterated his stand that he is entitled to special treatment as a past precedent. Where is the consideration? And then, Millard, please see page 37.
There's a communication.
Yes. Millard, that's the only thing the club notices. And this is, Millard, this is paragraph 51 of our application and dealt with in page 34, para 34, page 37 of the affidavit in opposition.
Para 51 of your petition, which page?
Paragraph 51 of my application.
64.
62. And
No, 54.
I'm sorry, Millard, please. Yes, this is page 61, para 51. And this is dealt with in Millard, paragraph 34 of the affidavit at page 37. There is no dispute.
Page 37.
Yes, paragraph 34.
Yes.
So, Millard, it's a very shows, Millard, extreme perversity when you don't consider. Now, Millard, if the minutes don't record this and don't, Millard, consider and reject this.
No, that how the court can consider this has been given, means you have stated in the given, because it is on 29th and
Yes,
meeting was
no,
27.
Millard,
You are
that's
telling that
mentioned,
it is
Millard. Please see the notice at page
274.
274.
Correct.
And
You are stating that you have stated,
yes,
but
I am stating that I have stated.
correct.
They are not disputing it. They have not issued an
Okay.
email saying that you have not said this. In the affidavit, when they are dealing with the letter, they are also not saying that none of all of this that happened, you're lying.
Yes. Okay.
Your contents of your letter are all your imagination. You never said this.
Okay.
Now, in this situation, that's why, Millard, I said that now with the affidavit, Millard, I have something to argue. Earlier, it was in the blind. Now, if you don't consider this, this is extreme perversity.
Okay.
Now, very important, Millard, this is number one. So this, the only, Millard, mitigating factor is not taken into consideration by the committee. And the stand, Millard, is that you did not give your reply, so therefore I am not going to, Millard, allow this. So this is a decision without considering the only explanation and shows the perverse mind of the decision maker. Second point, Millard, now. In the affidavit, please take the affidavit in opposition.
Yes.
At page 9 is the first, Millard, reference to, Millard, formation of MRC. Because now the biggest question is, how much, my lord, will I be penalized for not answering the questions of the MRC? Then I'll move into, my lord, because if MRC falls, whole thing falls. I'll now address these aspects. My lord, page 9.
29 September.
Yes, 28 September.
Yes, 28 September.
28 September 24. First meeting of the newly formed executive committee. And then, my lord, second part is verification by the club to ascertain if plaintiff has in fact circulated the undated and unnamed circular on 23rd September through WhatsApp. My lord, please see, my lord, the 28th September minutes. He's crave leave to refer to them, my lord, in his affidavit. He should actually be giving me a copy, but I don't want to get into this. If your lordship sees, it's good enough. Yes, but the last meeting of the old committee.
Three meetings. As per the rules of the question, one of the outgoing committee every year at the AGM, take the money. Then the AGM and then another meeting of the newly formed AGM.
Correct.
There should be three.
Normally, my lord, what happens is three meetings. Old committee has a last meeting. President says thank you to everyone. I'm going.
Then
Then,
welcome.
my lord, the AGM, and then, my lord, newly elected committee may or may not meet. My lord, where I have served in other clubs, newly elected committee doesn't meet. They all, my lord, go to the bar after the AGM. But I don't know if they meet, they meet
With the welcome drink.
with the welcome drink. But this is a different matter. Lord, Lordship has seen 28th September, Lord, in the
Yes, I'm going through.
Yes. Only thing I'm sorry. Lord.
Yes.
Lord, the narration in the affidavit is verification by the club to ascertain if the plaintiff has in fact circulated undated and unnamed circular. I hope that is there, my lord.
Yes.
Undated, unnamed. My name shouldn't be there.
No, that is.
That I must give your lordship a brief, my lord, background to how the minutes book came. The learned judge, hearing the matter, directed them to, because there was a huge fight about, I said, I want to see the minutes book.
Yes.
So they said, no, we won't. We'll show it to court if required. So they produced it, and then they didn't want to leave it behind in court.
Yes.
They said, court can't have it.
Yes.
The learned judge passed an order saying, no, this has to be there.
Okay.
So, my lord, as per their version, on 28 September 24, the minutes should have no mention of Jai Surana. Because it says undated and unnamed circular. Plaintiff has circulated undated and unnamed circular. Maximum it could be that Jay Surana has circulated an undated, unnamed circular, and we must verify from him whether he has in fact circulated.
Yes.
On 28th September.
Yes. Next.
Now, my lord, an MRC who's done everything in this case, in the history of the club, my lord, it wasn't there. What, my lord, the affidavit is, my lord, clear at page 10. My lord, please come to page 10. 19th October 24, Executive Committee's decision to refer the matter to MRC to investigate and inquire into the matter. Investigate and inquire into the matter. Is there a list of dates, affidavit?
Yes, yes, fine.
Now, two things, my lord, happen. And two things are clear, which means that this committee, for the first time in the history, has set up an MRC. Now, before 19th October, the only date it could have done so is 28th September.
That is the only meeting.
There is no reflection, but constitution of MRC has to be there to investigate.
Correct. Constitution of MSC, the executive committee decision.
Yes,
It is said that executive committee decision to refer the matter.
yes.
And by which?
No, the reference is on 19th October,
19th
but
October.
constitution is 28th September.
Yes.
Because the committee only met once before this on 28th September. It did not meet in between. So, my lord, therefore, 28th September meeting would have constitution of an MRC. My lord, please see what the MRC has been, my lord, constituted to do in the minutes of the meeting of 28th September. Is it for investigation or is it for the purpose of interacting with members who have complaints?
Now, then the question arose, if on 28th of September, the committee is not aware whether the letter was written by Mr. Surana
Yes.
and which date and whose signature. If it is not that, how the MRC can be constituted on that day without the verification of the
That's the point. These are all, I'll show your lordship. I can't establish it. Nobody can. But these are all tailor-made minutes.
No, but where is the executive? Where is the constitution of the MRC?
Milord, has to be on 28th September. September. So, Milord, lordship sees 28th September minutes.
Yeah, that is
Whether MRC formed and has to be formed on that date. If they when they make the minutes, Milord, it has to be on that date. It can't fit into any other date. And lordship will see what MRC is supposed to do.
yes, MRC. Yes, it was proposed to
It
constitute.
has to be to interact.
Yes.
Now, my lord, what is role of MRC? It is there, my lord, our friends, my lord, at the club tell us, because we have no access, that it is for interaction with members who have made complaints. It is not for the purpose of, my lord, participating in suspension proceedings.
Yes.
Yes. Now, my lord, if it is for the purpose of interaction, that it's with members who have complaints and grievances, then there is no delegation of power to the committee to, my lord, participate in or be a part of suspension. And this has to be in terms of the rules. My lord, now I'll show your lordship the rules. Jurisdictional error.
Page 118.
My lord, please have a look at
Page 118, Rule 42H.
my lord, page 118, Rule 42H.
One one eight
Yes, my lord.
of your application.
Yes, my lord. Rule 42H. MRC is only somebody has a complaint to discuss, etc., etc. And that's possible under this clause, my lord. This is, my lord, this starts from Rule 42, starts at page 116, Committee Special Powers.
Yes.
And, my lord, H is,
H is the appointment subcommittee.
yes, to appoint
Purpose.
subcommittee for special purposes consisting of such members of the club, whether members of the committee or not, as they may think fit, and now, my lord,
Delegate.
and delegate to such subcommittees such of their powers as they may seem fit. So, my lord, your lordship, my lord, I am doing this blind, based on, my lord, what friends have, my lord, said. But your lordship will see, my lord, the minutes creating the MRC. There has to be, my lord, a specific delegation to take part in, my lord, disciplinary proceeding, to frame questions, to put, my lord, show cause notices. Because delegation is needed as per page 118. There has to be a specific delegation. My lord, we are, my lord,
MRC has been defined in the bylaws.
no, 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 no. So the committee's power, my lord, is to suspend. There has to, let's, my lord, put it this way, to even participate, there has to be specific delegation. And, my lord, friends at the club tell us that MRC was created only for the purpose of addressing grievances and, my lord, dealing with, my lord, complaints of members. So the whole action taken by the MRC in the absence of delegation under Rule 42H1 is void.
Okay.
Lordship will, my lord, again, just for once, see the 28th of September meeting which has, my lord, which is the only meeting which can have constitution of MRC. And your lordship, if at all it is minuted, your lordship will find, my lord, it's for interacting with members for their complaints. It doesn't have any jurisdiction to deal with, my lord, participation in suspension proceedings.
Yes. And if the complaint or they are telling this is a defamatory letter, whatever it may be
Yes.
called, if he stated that it is specifically to be dealt by the AGM, whether the MRC can act upon.
This is my lord,
Because
democracy.
in the complaint, he has stated that to discuss in the AGM.
AGM.
To discuss in the AGM, though they have produced 2-3 points have been discussed.
Yes.
If it is discussed, so what is the purpose of MRC?
What is the purpose of?
Yes.
Now, my lord, if you feel that you've been defamed, there must be some basis. My lord, please have a look at. I'll just take 2 minutes on, my lord, the Chandar Khator report. My lord, I had told my leader, my lord, in the matter in the first round that there's no point going into it now, because unless they have a chance to deal with it at the ad interim stage, my lord, court will not, my lord, go into these issues at the ad interim stage, because, my lord, these are serious accounts issues. Now, my lord, see the Chandar Khator report and the affidavit in opposition.
Page?
My lord, 227. We showed it, but not, my lord, in the way I'll show it now with the affidavit in opposition. কোন প্যারায় ডিল করেছেন? আরে ভাই কত কথা বললি? 227, my lord, please come. খুঁজে পাচ্ছি না, সব উড়ে গেছে।
227. So you are looking at the appeal, right?
No. Lord, I don't know for what reason all my notes on liquid text disappeared. We are making it this morning.
299 of this.
No.
The 299 of this
Okay.
is the Chandar Khator.
I'm sorry, my lord, please give me 1 minute.
Next one.
Oh, it's in the next one. My lord, please come to page 227.
Yes, the report.
Yes,
page.
my lord, this is. Oh, no, I can't tell you. My lord, please, first, my lord, page 231. As per audited financial statement, management has incurred following capital expenditure during the year. And it adds up to 8.35 crores of capital
The
expenditure.
23-24. These are
But-
23-24.
No, my lord, I'm reading page 231.
Correct. 231. Observation of the review.
Yes.
23-24.
Yes.
Yes.
That's, my lord, up in the AGM on
Correct.
24. My lord, as per audited, below that, misleading incorrect statement disclosures, capital expenditure. As per audited financial statement, management has incurred following capital expenditure during the year.
Yes.
Building, furniture, fixture, equipment, 8.35 crores. Our observations are as follows. Yes, our observations are
As follows.
as follows. Then there is no detailed explanation of incurring such a huge expenditure in the president's report to the members. It only mentions under other club activities. Then about club notices, etc. Then investments at page 304. I'm sorry, 232. The president's report says the club financial health remains strong, with reserves growing from 52.13 crores to 61.05 crore. The above are invested to secure financial instruments that continue to yield stable returns. Next, club has sold, redeemed the following investments during the year. So, investments of 5.3 crores were liquidated. And the club has further invested in the following years, 5.36 crores invested.
So this is the report of yours or the?
No, our report. Because we
You have
went to
conducted
an auditor to bring it,
not
our
of the
then-
not of the
not of the club. Our observations are as follows. As per financial statement, money invested in investments yielding stable returns are as follows. Investments in bonds and securities, fixed deposits in bank. Then there appears to be a significant gap between reserves vis-a-vis
Mr.
investments.
Chaudhary, what would be the value of this report?
This is just a collation. Just a collation of information available from a balance sheet, which could have been or should result in a healthy discussion.
Balance sheet has already been forwarded to you before the AGM.
Yes,
Correct. And that balance sheet
shows this.
So, okay.
I want to say the reason why I'm reading this out for your lordship is that what I said was not unfounded. What I said is now backed up by an auditor's report. A famous chartered accountant firm has also said that these are the problems in this balance sheet. Let me show the main problem first. Please come to 237.
Yes.
Changes have been made. Lordship will find in your lordship's records a blown up page of the petition. Page 234, I think, has been blown up. 240? 248 has been blown up for your lordship's reading.
248.
Yes, my lord. It's in the, we gave it because it's easier to read if it's bigger. Achhe.
This is a defendant company, and this
is their balance sheet.
defendant club.
Yes. Now, my lord, see. কোথায় তোমার দাগ দেয়া কপিটা দাও না লিখছো না কেন আমায়? Yes, my lord, please come to page 3. I'm sorry, my lord.
48.
248. My lord, on the left hand side is the income and expenditure account for the year ended 31st March 23. And before that is 31st March 22. My lord, two columns, 23 and 22. Next year, my lord, income and expenditure account for the year ended 31st March 24. Here they have given 24 and 23. So 23 is common. Now, my lord, see, under the heading, first, my lord, please see.
Departmental surplus.
It's income, subscription and fees, then
Departmental surplus.
yes, departmental surplus.
1 crore
Deficit.
76.
1 crore 76,91,699 in 23. Now, my lord, please have a look on the right hand side of the page, where 23 is reflected.
147.
The closed accounts of 23. So what you're doing is 23 accounts are closed, audited, accepted by members at AGM, published, filed with authorities. In the next year, you've started changing figures.
Reflecting the amount.
Yes, different amount. How can this happen? And there are 25 such instances in the accounts.
The one in the bracket is a deficit, other
Please see other income. In 23, they had shown other income as
1 crore 31.
yes, deficit, within bracket, deficit.
Deficit.
And now in 23, on the right hand side, they are
55.
showing that there was a profit of 55 lakhs.
55.
So you're now tinkering with closed accounts.
Other income and other income net.
Yes. 23, other income minus 131 on the left hand side. This is final balance, a published figure.
It is the minus.
It's because in bracket.
Yes, bracket, yes.
Now, on the right,
55 is
55 is plus.
net.
I am not an accountant, but my question to myself is that in a concluded balance sheet or concluded accounts accepted by members, how can you change figures? And 25 times. I'm sure under our accounting standards, this would be, possible. Maybe possible, I'm not sure. Maybe possible. But it's a matter which must be brought to the notice of the members. And our chartered accountant, who's given this balance sheet, says at page 237, changes have been made. 237 at the top. Our observations are as follows.
Yes.
Changes have been made in 25 places.
Yes.
Total income as well as total expenditure as per such and such are changed in the previous year column of the audited financials of financial year 23-24. New head of expenditure. Expenses for children's sport and club events net amounting to 2.16 crores added. Even figures of provident fund, pension fund, employee state insurance, for which returns to statutory authorities, such as provident fund, employees ESI, which was submitted, have been amended. How can this be changed? 23, when the accounts were prepared, we knew what we had submitted to PF, etc., etc. Now, how can you next year on the right hand column change those figures? Then the above unexplained significant changes raise questions on reliability and integrity of the financial statements. In such and such case, it was cited by the Ministry of Corporate Affairs through Office of Registrar of Companies. The figures shown in one financial year should exactly match when used as part of the previous accounting period in the next financial year. However, the subject company has deliberately changed the figures and explained it as part of regrouping, which is unacceptable. This is some IT judgment, Millard. Then Commission of Income Tax versus Morgan Securities, High Court expressed doubts over regrouping of previous year's figures. The above judicial precedent suggests that changes in audited financial statements are observed to be unacceptable and raises doubts on management practices. So, Millard, what did I want? I wanted this to be brought to the notice of members.
Yes.
Then, Millard, please come to page 238. Ambiguous figures requiring adequate explanation. Millard, please see number C. as per Employees Provident Fund, contribution to Provident Fund is distributed between EPF and EPS in the percentage of 8.33 and 3.67. As per audited financial statement, the following expenses have been shown under administrative expenses, such and such. Assuming that pension fund mentioned above is a component of EPF, the distribution percentage is not as per statute. This has not been explained.
Yes.
And Millard, it goes on. Then Millard,
Yes,
please come.
what are the, he has found, he has given the opinion.
Now, yes,
observation.
his opinion of a chartered accountant that these are, he doesn't say, Millard, that these are fudged or anything, but he says this is most abnormal. Now, what do I say? That this should be, Millard, decided. Now, I'll show your lordship the notice convening the EGM, forwarding the accounts, and the number of days given for members, Millard, to respond. Millard, please see page 209. Why are you standing? Sit here, sit here. What is the problem? Take to page now so that I can consult Dhruv. Well, 209, please see the date.
28th September.
Yes. Notice is hereby given. No, that the meeting will, notice is given under Rule 48 and 52.
12th
Yes.
September it is given.
This is given on 12th of September
Correct.
for a meeting on 28th September.
September.
Now, my lord, please see the bottom, the asterisk at the bottom. To facilitate adequate replies to members' queries, only questions received before 20th September will be entertained or replied to. No other questions, discussion, resolution may take place. So I had 8 days to read the accounts, to find the problems, and to intimate them. Otherwise, this itself is oppressive. It's a members' club. Why are you so secretive?
That's the rule. All financial issues.
And for the first time, this has come in. That you only have 8 days. So, my lord, I issued that circular. I did not have, I went and sat with Chandar Khator, who did not give me the report within, it's not possible. 2-3 days it takes me. Then I go to them. They look at it for 2-3 days, then prepare a report. So little of what they told me, I issued that circular. Then they gave me this report.
When this report was obtained by you?
This report was 1st October. And it's annexed to the petition. Now,
October 25.
24.
24.
24.
Yes.
Now, my lord, the amazing part is that all of this is before, my lord, is part of the petition. My lord, please see how they deal with Chandar Khator's report. Because that's, my lord, my assertion justifying my stand. My lord, please see paragraph 31 at page 32. It's, my lord, paragraph 27 at page 39 of our application dealt with at para 31 at no, I'm sorry, we're at page 31, para 29 of the affidavit in opposition. Now, please see page 31.
Page 31 of AO.
Of AO.
Correct.
No, I mean, keep.
No, that is kindly. You,
Oh, I'm sorry, Millard. I am
31.
31,
Page,
Millard.
paragraph page 32, para 31.
Yes.
Auditor also smacks the malafide.
Malafide. The action of the petitioner to appoint an external auditor smacks of malafide on the part of the petitioner. The alleged review of annual report for the financial year 22-23 conducted by the external auditor appointed by the plaintiff was unilateral and without the knowledge of the club. It is significant to note the chartered accountant admittedly did not go through the books of accounts of the club. This report of 1st October 24 is unauthorized, unilateral, does not show true and correct facts, and has been made unauthorizedly, unilaterally, and could not have been made without understanding the facts and the books and accounts of the club, and thus cannot be relied upon. The alleged non-compliance observations pointed out by the auditor are without considering the true and correct facts and financials and books of accounts. Issuance of circular dated 22nd July by the petitioner is also an act of interference with the smooth functioning of the club and a malafide attempt on the part of the petitioner to disgrace and malign the office bearers of the club.
Yes.
So, my lord, not a word dealing with any of this. My lord, I didn't have the advantage of, my lord, this at the, my lord, ad interim stage. Now, my lord, the next point. I'm not going to read those letters again, my lord. Your lordship will recall from the ad interim stage. In fact, I'll request, my lord, my ad interim notes of argument has a list of dates. My lord, they show that from the date of the meeting of the, my lord, MRC till the date of suspension, they went on saying that minutes, transcript is minutes, and my lord, I kept on disputing it. I would have thought, my lord, that there would be a proper minutes, and those minutes, my lord, would be considered by, my lord, the club in its executive committee, MRC minutes, because not doing so, because the affidavit now makes it clear there is nothing to that effect. Now, my lord, please see Rule 51. At page 132.
Yeah, 120.
At 122, my lord, I'm sorry.
There should be a red book of with that given justice.
Yes, yes, it is there. उसमें नहीं कोई एक फाइल में ही रखा है
It will be easier to handle for my lord.
ये कोई फाइल में है रात को देखा वो कुछ फाइल का
Yes.
Bible of the club.
Bible of the club.
Yes.
Created by persons who never thought this day would come. Please see page 122.
Fully agree. I agree wholly. Creators never thought it'll come to court.
Yes, yes.
Page
Of course.
which
Never thought your clients would become committee members also. Milord,
which rule? Which rule?
Milord, Rule 51. The minutes and the resolutions
Yes.
passed at each meeting of the club. Milord, this is both committee and general.
Yes.
So also, Milord, MRC. Because MRC now, Milord, we know it's a 28th September, it's a validly formed committee under, Milord, 42H. So, Milord, it's a committee. It now has to, Milord, stand by this. Now see Rule 51. The minutes of and the resolutions passed at each meeting of the committee and at each general meeting of the club shall be fairly copied in a book and signed by the secretary and the chairman of each meeting. The minutes of the annual general meeting shall be open to inspection by members. So, my lord, MRC minutes. Now that you have kindly,
But you have accepted.
I'll come and I'll deal with that. I'll deal with that. That's something I'll have to deal with. I'll deal with that. But I am on a different point. Rules have to be followed.
Correct.
We now have the minutes of 28, at least your lordship does, I don't, which shows, my lord, that MRC is constituted. Now, if it's a validly constituted committee, my lord, in that case, has to be minutes. Now, let's, my lord, come to acceptance. And also, my lord, 3 years back, the same coterie of persons with, my lord, 1 or 2 changes during COVID had, my lord, tried to hold an AGM. My lord, there was also, my lord, disturbance then. They tried to hold a AGM. This plaintiff, my lord, came before this honorable court and said that you're trying to keep out people. You can't do this. Rules don't allow. I had moved the matter. My lord, please see the order. So what? Please see the order, my lord. পাতাটা বলো না, আমি সব উড়ে গেছে। 154. My lord, please come to page 160. My lord, 4th line towards the middle. Unlike a company which permits proxy voting.
160,
Yes, my lord. Order starts at page
154.
154.
Yes.
My lord, 160,
Yes.
7th line from the top. Second paragraph starts with, my lord,
Rule 30.
consideration rule 35. Unlike a company which permits proxy voting, the rules of Calcutta Swimming Club are altogether different, where only physical voting is permitted, save and except Rule 50, which was amended on 26th of December, permitting e-voting. The question is not whether there is a possibility of election being robbed of transparency. What is more relevant is whether the committee has compromised with the checks and balances built into the rules by holding election on the virtual mode. Next, my lord, please come to the next page. My lord, page 161, 3rd paragraph. That the rules of an association or a club bind the members and are sacrosanct, and the court can step in to ensure strict compliance thereof, has been reiterated in various decisions, from Enderby Town Football Club to TP Davar to BCCI to such and such East Bengal Club. This court leaned in favor of intervention by a court upon a justifiable apprehension that elections. That's a different matter. But this club, 4 years ago, this court has held rules have to be followed. And ultimately, my lord, the elections were not permitted. The reasons have been given. So now, my lord, if rules have to be followed, my lord, your lordship will please see now, I mean, notes of argument to what extent, my lord, waiver applies and how I have waived. For that, I want your lordship to come to the minutes.
Which date?
Or, my lord, I'll do it quickly from my notes of argument, which I'll just use the list of dates. My lord, if your lordship has the trial court, the ad interim stage notes of argument.
मानो तो शीर्ष में देखो notes of argument. Defendants का.
Petition টা বার করো. Petition টা physical copy টা বার করো. My lord, first is
Just a minute.
the supplementary affidavit
This one.
Yes, Milord. Milord, please come to page 2, 8 November 24.
Yes.
Meeting held by MRC. Before this, Milord, only 2 letters, in fact, one from the club. That is, Milord, important because that will give the background of, Milord, this matter. It's, Milord, 9th October at 2:55. Now, please note, this is below the secretary writing, importantly. Please note, undersigned has received a copy of
where
a
from you are reading?
255 of the petition. Milord, some documents I'll quickly refer to and follow the sequence given in the list of dates. With the background, Milord, now that I have, Milord, a constitution of MRC, with the background, that must be something very, very serious for, Milord, MRC to keep functioning without minutes. That's required under rules.
Yes.
Now, Milord, see what's happening. Milord, the secretary writes and says that please note that the undersigned has received a copy of a letter circulated over WhatsApp about 4 to 5 days from one of the members of the club. On perusal of the same, it has come to the notice of the undersigned that the same has been issued under your signature. Before proceeding further, undersigned thought it would be prudent on his behalf to confirm from your good self whether the said letter has been issued by you or not. You are requested to confirm the same to the undersigned by means of your response over email. Milord, this is, Milord, 9th of October.
9th October 2024.
9th October. Milord, before this, Milord, nobody, there are no minutes which, Milord, asked the secretary to issue this notice. What is on record is some of the committee members orally asked him. Milord, that's not so relevant, Milord. I don't want to digress from the main chapter. Milord, we proceed, and then, Milord, comes the secretary's email, and then the email Milord, email asking us to appear before the MRC, which is at 2:57. This only says WhatsApp communication found floated, and committee has decided to refer the matter to MRC. Pursuant to the aforesaid resolution, MRC has decided to hold a meeting at 1800 hours, wherein you are requested to appear before them to explain contents. There's one thing I'll not show your lordship. 257, Lord, please see the first paragraph. Your reply was placed before the committee and it was decided to refer the matter to MRC comprising the following members. Milord, if there was an MRC before, Milord, this date, the club would have known, they would have put it on the board. Nobody knew about constitution of this committee. Only when we came and argued that under 42 age there is no delegation and where is the formation of the committee. Milord, now the first meeting of 23rd September shows formation. Minutes, Milord, are not in our hands. Nothing to know, Milord, who drafted the minutes when they were drafted. But, Milord, if I have an MRC, Milord, I have an MRC, and Milord, what would I do? First day, I'm a president of a club, I form an MRC. I'll put it out on the board tomorrow that there is an MRC now formed. Has it come? Never. And why do I say this? Because in this email, he also gives the constitution of the MRC. So if, my lord, the constitution of the MRC was a publicly known fact, this email would have never had that. Anyway, my lord, that's neither here nor there. I'll proceed. So I was asked to appear before the MRC. Now take the
No,
supplement.
kindly read is.
Yes.
The WhatsApp communication dated nil. That is the same.
Yes, yes.
Correct.
Found floated
to the members of the club and few days prior to the AGM. No problem. The email of the undersigned addressed to you on 9th October, your reply thereto on 19th October were placed before the committee in the committee meeting. Which committee?
Main committee.
Main committee meeting, when the main committee meeting was held?
There is a
Held on
23rd October. 23rd October, it's mentioned here. For placed before the committee in the committee meeting held on 23rd October.
Yes.
So, my lord, it's placed on 23rd October. If it's placed on 23rd October, my lord, the letter of the first letter of the secretary to me
9th of
is 9th October.
Correct.
Who's authorized you? My lord, first is committee meeting on 23rd, 28th of September. Then, my lord, on 23rd October, committee says you go to RMC, MRC. So who's authorized the secretary to write before that date? That's the genesis. Are all these made up documents later? 23rd, 28th of September, my lord, as the past president says that I put it before the next year. I didn't want to deal with Jai Surana problems.
Correct.
And so that's the first meeting on 28th. Second meeting,
23rd.
no, second meeting on 28th of the new committee,
New committee.
only
28th of
forms
September.
MRC for my lord, grievance redressal of members and nothing else. Till then, my lord, there is nothing. Now, suddenly, on 9th of October, secretary issues email to me. Who's asked? He's an employee. Who's asked him to do so?
What is the duties of the secretary?
Duties of secretary, my lord, would be in the rules. And he'll function as per the instruction. That's important. I'll also quickly check. That's an important point, my lord, which didn't strike me.
Yes.
Huh? Yes, my lord. Page 111.
Rule.
Secretary and or managing member.
Rule.
Rule 33. Rule number 33.
Secretary. The committee may time to time appoint.
Yes,
pay,
that's
remove,
the point.
So,
The committee may from time to time, second paragraph, I'm sorry, first paragraph, committee may from time to time appoint, pay and remove or dismiss a secretary and or managing member and shall have the power to settle the remuneration and other terms of service of such secretary or managing member. Committee shall have the power to depute to such secretary and or managing member such duties as they may from time to time think proper. So, my lord, prior to this notice coming, Where is the direction of the committee? There is only one meeting of the committee. Who's he? And he's writing to a past president. Who's he? Now, my lord, this is, I'll come back to this, my lord. This is reflected in the minutes. So, pursuant to all of this, now please take the supplementary affidavit.
Filed by you.
Yes, my lord. Which has
27th February.
আমার এখানে কলকাতায় ছিল।
Sir, volume 4.
হ্যাঁ, পেয়ে গেছি, পেয়ে গেছি।
Formed on 27th of February.
My lord, 27th February affirmation.
Yes.
My lord, let's start at the very beginning.
That's the transcription of the.
Yes. Jai Surana. First, Kanan Tandon speaks. Thank you. The reason we are here is known to you.
Which page you are reading?
My lord, page 8.
Yes,
Transcript of video recording.
correct.
Letter is also from the secretary asking him to come before MRC in connection with that document. No, it is not known to me. I have been asking about this in my last 3 letters. Why I have been called, I was never told anything. I think I was intimated to you with regard to your letter, which you have written to all permanent members of the club prior to 18. It has been there before. It is in that context that we have called you. If you take the first letter of the secretary, which came to me, Kanan Tandon, that was on 9th October. Jai Surana, that was on 9th October. Yes. He says, please note that the undersigned has received a copy of a letter circulated on WhatsApp about 4 to 5 days before the AGM from one of the members of the club. On perusal, the same has come to the notice of the undersigned. So, undersigned is secretary, same has been issued under your signature. Kanan Tandon, yes. Jai Surana. Before proceeding further in the matter, I don't know what right he has to proceed further in the matter. Who has given him the right to proceed further in the matter? That is secretary.
So you have raised the objection. on
Yes,
that.
answer. The undersigned thought it would be prudent on his behalf to confirm from your good self whether the said has been issued by you or not. You are humbly requested to confirm the same to the undersigned. So he is asking me, do I confirm him? That is the undersigned is secretary. Whether I have issued the letter or not.
Objection was issued on 19th October also.
Same objection I have issued on 19th October by email that you secretary who's given you the right. Then, my lord, Kanan Tandon says yes. Jai Surana, that means I have a response from the email. Further note that if the undersigned doesn't receive any response from your end, then it will deem that same has been issued by you. So this is the letter issued by the secretary to former president asking him to please tell me. Is it some sort of suo motu step he must have taken? I don't know how he has taken this. What right does the secretary have? Kanan Tandon. Now this is very important. See, basically, Mr. Surana, you are aware the secretary will do things as directed by us or the committee. And we got this letter, so we had asked him. Normally, all the correspondence has been right from the earlier date, from the time at least last 8 years, which I know has been issued by secretary. On basis of our instructions, he has written the letter. So, my lord, even before, now MRC is a committee, even before the MRC meets for the first time, without any written documentation, MRC authorizes the secretary to write. And Also, my lord, when was it referred to the MRC? Lordship recalls? That's
October,
October,
9th October.
9th October, 23rd October.
23rd, sorry, 23rd.
And when is the letter issued by the secretary? 9th October. So even before matter is referred by committee to MRC, MRC issues directions without holding a meeting, without there being any minutes, to the secretary to write. My lord, this is all a toy house, my lord, created, these minutes.
Yes, next.
Now, my lord, let me read on. My lord, page 10. Jai Surana. But nowhere I find that it is under your instruction or under instructions of the committee. I don't find a word. My lord, please remember at this time when this was happening,
Page.
my lord, page 10 of the supplementary affidavit.
Running page.
Yes, my lord. And internal page 3 of the transcript. Lordship will, my lord, just remember this. At this time, my lord, my lord, when the meeting is happening, matter hasn't come to court. We haven't argued. My lord, all of this will show that all these records, my lord, have been created subsequently. But nowhere I find that it is under your instruction or under the instruction of the committee. I don't find a word. What is the answer of Mahesh Punjabi? Fair enough. Then Mahesh Punjabi says, our intention was not even to call you, sir. Maybe the letter was. Normally communication goes to secretary. Fair enough, your point is well taken. But it has gone with our instruction. So MRC or, my lord, a coterie is acting without, my lord, authority in this matter. That's the genesis. The first step, my lord, is that letter from the secretary. And that is, my lord, issued by a coterie of persons without there being any minuted decision either of the committee or of the MRC. Minutes show, my lord, MRC is authorized. MRC wasn't even given the job by that day. Now, my lord, only point we want to understand in this letter, which is written, sir, let me finish. Is it written by you or not? Nothing else. So, my lord, at the MRC meeting, Mr. Mahesh Punjabi makes it very clear that the only point we want to understand is whether letter is written by you or not. Now this, my lord, last time when, my lord, we were reading this before your lordship, we didn't have the affidavit and your lordship didn't have the meeting minutes. Object of MRC is to address grievances and, my lord, deliberate with members. Is this an expression of addressing grievance and deliberation with members? I ask myself the question. He says, I've only called you here to know whether you've written this or not. That's all. Answer is, I've sent it by my phone, I've sent it by my mobile. So you're saying you've written that? Answer, no. This is the situation. Last year before AGM, when a different committee was there, I had sent it from my mobile. It is not that somebody sent it from somewhere. Fair enough, that's all. That's all. Second last entry at page 10. That's all.
Yes.
And then, my lord, next page, I say, where is the question of asking me? He must have pointed out to somebody. Anybody of you could have called me and said, I have written it.
Yes.
And then, my lord, now come to page 12. Heard from the top, Jai Surana. See, nobody asked me any question except whether it is my signature or not. I am not prepared to answer what I don't know what you will ask. So you give me a question, I will give you a written reply so that everything is in paper, pen and paper. This is what was shown to your lordship. That he is accepted that he will answer questions. Why is he refusing to answer questions? Then, my lord, Mahesh Punjabi says, correct. Then, so after you have given me the question, you give it to me, give me some time. Then Jai Surana says, tomorrow I'm going out, I'll be back on the 13th, 16th, the party, I'll be at the party, give me time till 20th, I'll answer whatever question you have. Mahesh Punjabi, yes, but right now this meeting, which was not required, sir, you could have just sent me an email saying this letter. Jai Surana, he could have called me, I would have said yes. See what is secretary, you read his next letter. Please refer to the email signed. I am still unaware. I write to him, I'm still unaware. This is what he does. I give him a reply to this letter like a small baby. He runs to the committee and says, I've written a letter.
So this was only to make the confirmation, take the confirmation from the plaintiff whether he has written a letter or not. Whether it was necessary. Why I'm telling you, even you have to give the reply. In 28th of September in the meeting, you have taken the decision the letter was written by the Surana.
28th September meeting.
So why you have given this? You take note of it.
I will note.
Yes.
Well, I'll just read on. Kanan, then Millard, page, internal page 6 is page 13. Kanan Tandon, there is nothing we are discussing. Firstly, we wanted confirmation whether you have written the letter. You said yes. Yes, Surana, it was over. Just a minute. How can I say no? Then Kanan Tandon, no, let me tell you, because of this particular thing that was written, it's shocking, etc., etc.
Yes.
Then, Milord, please see page 7. I'm sorry, Milord, internal page 7, running page 14. Even before the committee, even before Milord matter came to court, Milord, Mr. Surana was not arrogant, as they say. This, Milord, see what Kanan Tandon says. Significant financial irregularity. It demeans the entire committee and the institution. What is his answer? Sir, I am sorry. Just Milord, quickly read on, Milord. I won't read the whole thing. Then, Milord, again, internal page 9, page 16, Milord. I say that you give me a question, I'll give you an answer. Then, Milord, towards the middle. I know that, sir. We are not expecting any answers. Mahesh Punjabi. Lordship has seen that. We are not expecting any answers. Then, yes, we are not expecting any answers from you. Our only reason for you is what Rishi says. And Milord, please go to the previous page. Please see what Rishi says. No. Allow me to explain. Milord, previous page, Milord. This is page 15.
Yes.
No. Allow me to explain. So, number one, firstly, as I said, he has written a letter to you, in which the letter is also attached, which is claiming and asking you to confirm if you sent it or not. That was his simple game on that day. The expectation from him as well as the committee was to get the confirmation that because, as Mahesh said, he did not have the letter.
Yes.
So he just wanted to be sure that it is being written to by you. Committee wanted to be sure of that.
Yes.
Then whether that probably confirmation would have come, committee or somebody would have spoken to you. This is what I assume. I don't know. I'm not part of that. I'm part of a different arrangement. So probably that is what would have happened. I'm not going there. I'm not going to any assumptions. Stepping forward, considering that now you have confirmed that you have sent this letter and you said that you still cannot understand what you have written wrong in this letter. You stated that point. Then,
Yes.
then Milord, please come down.
You complete before.
Yes, I'll complete before lunch, Milord. Milord, your Lordship has seen this before. I'm not, Milord. Milord, please come to page 24. I can't, Milord, read. Milord, middle of the page.
Yes.
Mahesh Punjabi, fair enough. Kanan Tandon, okay. Milord, before that is, Milord, what does financial irregularity mean? Am I imputing you or not? I said I'm not imputing you. Now, Milord Kanan Tandon, we will wait for your reply. Jai Suran, I will wait for your question. Yes, once you get the question, we will get the reply. Jai Suran, I must get the question. Kanan Tandon, basically that is now we will sum it up. You will get the question and then we will get your reply. Jai Surana. Probably he said he put up to the committee and the committee will think of putting a question. They may or may not. Because committee is to take steps. Jai Surana. So I take it for granted that the committee will put the question. Rishi Bajoria, no, we have not placed this before the committee as yet. There might be an error of a statement. Committee has not even met. This is such a telltale.
So what is this? What
No,
is
main committee. All are created later. All documents they are showing are created later.
Yes, next.
The committee has not even met. Once the committee meets, this will be placed before the full committee. That such is the outcome. The minutes of this meeting will be placed before the committee. And then, whatever is the final call, it will be taken at the committee. And the same shall also be intimated to you, prior to which the minutes of this meeting will also be intimated, shall also be intimated to you. So, my lord, they promise us two things. MRC, my lord, in the meeting tells me that I'll send it, I'm no one. I'm not going to do anything. I'm going to send it to the committee. Then committee may or may not ask you questions. Number two, they say that the minutes of this meeting will be given to you and to the committee.
Yes.
And three, then committee will give you questions, you answer the committee. Who are we? Our only job was to ask this. And as your lordship says, there was no necessity. So therefore, my lord, now, my lord, see the affidavit. Please see, my lord, the deceit in this affidavit. Please come to page 9. No, I'm sorry, my lord. 8th November. Yes, page 12. Last, my lord, box.
Yes.
Plaintiff appeared before MRC. Since secretary was not present due to ill health, with consent of the plaintiff, meeting was videographed. Correct? Ill health, we don't know. In the meeting, inter alia, the following transpired. Plaintiff accepted that the circular was circulated by the plaintiff through WhatsApp. Correct? B. The plaintiff refused to answer any further questions of the MRC. No, this is a club. It's coming before court. Is that the impression your lordship gets from the minutes? Transcript.
Yes.
But I read so much that they said that they'll give me questions, they'll give me minutes, I'll answer.
Yes.
And in affidavit they say plaintiff refused to answer questions. Then, but also it comes to my mind, what is absurd is they say we'll give it to the committee will ask you. Then why are you saying all this on oath before court?
Okay.
See, the plaintiff informed that he shall only answer the question if are sent to him in writing, along with unedited copy of the videography. I just want to go back to the minutes. I'm sorry, the transcript. I recall, my lord, last 2 pages, Mr. Singhi of the committee very clearly said that the minutes shall also be intimated to you.
Last.
Yes. So he promised to give me the minutes, and my lord, he did right. He did right because he is aware of the rules.
Then kindly come to the page 20.
20.
First 2 questions. Jasurana,
Yes.
now you give me a question.
Question so that I can give you an answer.
Now the
Sir, there is no question now. Then this is totally false. There was only one question, if you have written this letter or not.
yes. Next.
Next. Then, my lord, now just one thing left, my lord. Just one thing left. And I'm going to stop because otherwise, my lord, I'll take up too much time. My lord, there's that HIDCO matter, my lord, for allotments, which I had once done. There, my lord, what had happened was in HIDCO, they screened some 5,000 applications on one day. And in the judgment, which came from Justice Shonji Banerjee, his lordship, my lord, in his own inimitable style, said it must have been a very busy day at HIDCO offices. They met at 10 o'clock, screened some 5,000 applications in 60 minutes, and he gave the whole day. Same way, my lord. And I'm not just, we don't have time. I'm not reading that passage. But what I'm trying to say is that an unreal explanation of a day can be castigated by court and disbelieved. Now let's see, my lord, what happens on 18th of November, 2024. My lord, please see page 13.
Yes.
Of the, I'm sorry, of the affidavit, page 13 of the affidavit in opposition. Their list of dates. Meeting on executive committee held wherein entire video recording of the minutes of MRC held on 8th November was played. B. Questionnaire as requested by plaintiff be provided by MRC to the secretary. You formed an MRC, assuming all your records are straight. Who is MRC? Show cause law. Person who decides has to ask the question. Satisfaction. Prima facie, from the records, I feel that show cause, so I issue question. You have to reply to me. I have to decide whether cause shown. So, provided by MRC, not possible. MRC will ask questions, I will give decision. Then executive committee agreed to demand of the plaintiff and give directions to the secretary to send unedited copy of video recording along with questionnaire. 18 November. Now, my lord, please see page 260 of the petition. These are the most efficient people. I've never seen this kind of efficiency. My lord, please see page 260.
18 November.
18 November. Please see the time. 6:39 p.m. And what is this? This is, my lord, secretary communicating at 6:39. In furtherance to your meeting with the members relationship committee on 8 November 24, where you have confirmed or signing circulating undated letter through your WhatsApp to the members at large of our members about 4 to 5 days prior to AGM held on 28 September 24 and has desired by you, MRC seeks clarification of the following queries.
Yes.
Now, my lord, please see the time, 6:39. Now, my lord, please, lordship has the minutes book. It was a Monday, my lord. 18th of November was a Monday. In a club, my lord, normally nobody meets before 6 o'clock. Everybody, they're all, my lord, very busy people. Please see when they met. It is, my lord, not possible. All meetings are, my lord, in the evenings. It is 18 November. এটা বলো তো যে HTTP এটা তোমার না এটা?
Yes, 18 November.
Milord,
Not mine. That is the link of the video.
Milord, lordship has, Milord, would your lordship be pleased to indicate the time? I would never ask your lordship, but I don't have the minutes with me.
5 p.m.
5 p.m. Never, usually not done at 5, usually done at 6, but can be done at 5.
Correct.
Not, Milord, something absurd. People can take time out for such an important matter.
Correct.
But, Milord, so I have 99 minutes. For, Milord, what? for the executive committee to sit for 22 minutes, see a video. Because the minute says that we've seen the whole video. Where did I read from? It's in the opposition.
The entire video recording.
Entire video recording of MRC was played. Entire video recording. So 99 minus 22. Then executive committee discussed other matters also. Please see how many agenda is there in that in the meeting of 18th of November. This can't be the only agenda. And if it is, Milord, I'm proud that they've made me so important.
Yes.
Only agenda. Then, Milord, minutes are prepared. Minutes are transcribed. Minutes are signed. Minutes are communicated to the MRC. MRC meets. MRC.
What has happened after this? What has happened after this? These are three questions.
Three questions. So, Milord, what do I want to see? All of this is questionable. Because if the executive committee at 5 o'clock decides that MRC will communicate questions, Milord, then minutes have to be prepared. Minutes have to go to MRC. MRC will have to convene a meeting, sit, prepare questions, prepare minutes, sign the minutes, give it to the secretary. Secretary will have to write this email and issue it to me. So between 5 o'clock and 6:39, all of this happened. It's not believable, Milord. It's not believable. It's not possible. Huh? 70 minutes.
Yes, 70. 90.
No, 99 minus 22.
77
77 minutes. Milord, it's only 77 minutes.
Yes.
Milord, email is at 6, Milord, 39.
Yes.
Executive committee meeting is at 5.
Yes.
Executive committee has to, Milord, deliberate, prepare minutes, give it to MRC. MRC has to meet, sit, frame these questions. And, Milord, prepare minutes, or maybe they don't prepare minutes. They are a committee who don't prepare minutes, which is again wrong. And then give it to the secretary. Secretary will have to write this email. And send it to me. All of this could not have happened in, Milord, 99 minutes, out of which 22 minutes is the video recording of the 8th November meeting. And in their affidavit, they say that we played the whole video recording.
Yes.
Now, Milord,
Yes.
so, Milord, all of this, Milord, all these papers, Milord, are wholly unreliable. Milord, they also now say videography will be treated as minutes.
Yes.
Yep.
Next.
His analogy is superb. He says that tomorrow There'll be no orders, my lord, dictated by your lordship or transcribed. The court is now, it's on YouTube. So what your lordship will say is on YouTube. So you don't pass orders from tomorrow. It's on YouTube. We'll all go and hear what your lordship has said, and that we'll follow that. That is the order. Now, my lord, after this, my lord, are all letters. My lord, please take my notes of argument. I will not waste your lordship's time. My lord, this is after 8th November, from 18th November, page 3.
Yes.
It's all, my lord, that you give me minutes, I'll give you an answer. They said, I can't give you, I won't give you, you answer. Now, the fact of the matter is, what is so important is, Rule 51 says, now that we know, now that you have come out with your own version of minutes, you have said that you formed an MRC as a committee, delegating only limited power, but whatever, it is now a committee, has to be minutes. So MRC's no minutes of MRC is itself in flagrant violation. And I had said I'll give an answer, but if you give me the minutes, I'm acting in terms of the rules. You are no one to flout the rules yourself.
Yes. Any further?
I don't think so, my lord. Let me, and now, my lord, in this perspective,
Question given the fee and
yes. This is the division bench debacle. We will not. We were unable to explain. My lord, please see, my lord, page 36 of the affidavit in reply.
ये मनु तो रिप्लाई देखो. Now this court is conducting the disciplinary proceeding.
Yes. Absolutely.
Service matters wouldn't be done. Even service matters where bread and butter is involved,
Yes.
the court can't do.
The judges will throw the advocates. Yes.
My lord, page 36, this was not a part of the petition. It was said, my lord, that we have suppressed. Argument is, from their side, the argument is that in the meeting when you attended, you only asked these limited questions. So therefore, why did you give that circular? Now, my lord, when the question
Yes,
was
that,
put,
that I decided in my interim, ad interim.
now, my lord, I was floating, I was going in and out, my lord.
Yes,
Both
after
Mr.
affidavit,
Banerjee
yes.
and I didn't appreciate the situation. When the question again came from the division bench, my lord, neither of us were there. And when we came, we didn't really fully appreciate the question. Otherwise, we would have given this answer. There are three people. Umesh Goenka. We really didn't appreciate the question till the judgment came. When the judgment came, we understood what was in the mind of the division bench.
This is not correct. Mr. Ratnanko Banerjee gave a notice of mention.
Yes, and he mentioned.
Came back at 2 p.m.
Yes.
because of the and explained that after
Yes.
that the division bench.
No.
When this came from the
No,
Anyway,
that's
how
a
is
legal.
that-
There is nothing, neither here nor there. Now the court has to decide now.
Correct. What we didn't appreciate, we didn't understand what was in the court's mind, our inability. But, my lord, there are three people, my lord, asking questions. We are together. Jay Surana, Umesh Kumar Goenka, and K. Bhandari, Kamal Bhandari.
3-4 questions were there.
Now, please see page 36. I put 4.
36 of
36 of the affidavit in reply.
36, yes.
These are my 4. This is the.
This is a question which has been put in the
Maybe.
AGM.
Now, Milord, please see 37. This is what Umesh Goenka put.
Yes.
Is he a chartered accountant?
Yes.
Milord, all these accounts questions. And Milord, please see 38. This is what Kamal Bhandari put. So it's not that, and all of us went together. We're together in this. So, Milord, it's not that I have suppressed a letter where, Milord, I had asked limited questions before the AGM and raised 100 things in the Milord, in the circular. All 3 of us, Milord, if you read 36, 37 and 38 together, you'll see that it's all covered. We divided the questions.
Yes.
And that's reflected in the minutes of the AGM. আর কি পয়েন্ট না সারাক্ষণ
ওরা না আরেকটা ওরা বলছে ওরা কোনো রুলস ভায়োলেশন করেনি আর আমরা সেই কেসটা
ওটা ছেড়ে দাও
Just read the
No, no, no.
reclassification. They admit
No, no, no. Very well. They admit that there's been a change, reclassified. I don't want to get into all of that. Forget. Now, my lord, in this scenario, I want to, my lord, say this. If your lordship looks at the law, I know your lordship has held once that natural justice is not to that extent required to be followed at the suspension stage because you'll get a chance ultimately. Now, we didn't have the affidavit, we didn't have the minutes, we were unable to show so much to your lordship then. But my lord, I am requesting your lordship to kindly consider it from the angle of these facts.
Correct.
And
Now the court is hearing you on affidavits.
everything is
On
before the court.
affidavits and documents.
Now you will see whether natural justice is going to has
That is
been
it.
followed. And my lord, 3 points. Remember, my lord, that Bombay High Court judgment which Mr. Banerjee showed, that paragraph is also there in the notes. My lord, please consider modern day life, my lord. This is a huge, my lord, denigration to reputation, being thrown out of a club. So therefore, Bombay High Court says civil consequences apply. And to natural justice and rules that your lordships have also held in the past, all those judgments are there. Your lordship never meant that natural justice was not required to be followed at all. Your lordship meant because of, I must read your lordship's reasons with your lordship's conclusion on the law. That your lordship's reasons was that on the basis of material then before your lordship, which was the petition.
That
your
was the
lordship-
main this court has held that several opportunity was given,
Yes.
not explained to
Yes.
the committee or whatever it may be. So that's why if you got the opportunity or
Then
not
where is the
explained,
natural
then where is the
Then there's no
violation of
further
natural
natural
justice? So there was the ad interim is not required. Then the affidavit direction was given. That was the gist of the order.
Absolutely. Now the matter is different. And last thing I'll just say is, I want your lordship to, because I know they'll keep coming in the next part of the day. Please see, my lord, Justice Division Bench Order. Paragraph 32 of the Division Bench Order.
First division bench order
Yes, yes,
against my order.
yes, yes. That page 134 of the affidavit in opposition at page 161.
Yes.
Milord, paragraph 30. I'm sorry, Milord, paragraph 32. We clarify that all observations in this order are prima facie and have been made only for the purpose of disposing of this appeal. Learned judge is requested to decide the plaintiff's interlocutory application as well as the suit as and when the occasion arises independently in accordance with law without being influenced by any observation in this order.
Yes.
So, my lord, protracted submissions on this order, my lord, may not be very welcome. And the findings, my lord, are tentative and material was not there. Now, what happened?
Always in the interim, if it is appeal, whatever it may be, even not this court also, that is.
Or in them the next orator. Then what happened was, after we lost first round, and that was, my lord, principally because of that letter which we were unable to explain. Matter, my lord, went before learned single judge again. We filed an application. Lord, may I show your lordship that application? That is
What
G3.
was the occasion to file that application?
Lord, please see that application. কপি আছে তো দাও আমায় দাও So at that stage what had happened was division bench matter is over. We have lost at the ad interim stage. Division bench has said that you have to go before the special board and that your matter will have to be heard because affidavit directions are extended. Now at that situation, my lord, we file this application which is GA3. I'll just read out. Photocopy nahi? Sir, may I maybe show it from there? Like copy ano na keno office থেকে? My lord, in the meantime, my lord, few important facts are recorded in this letter. When the appeal was first, my lord, before Justice Showman Sen's division bench, I had mentioned, my lord, for the purpose of immediate, my lord, immediately being taken up. Justice Sen was pleased to indicate that don't do anything till I take up the matter. Till I take up the matter, don't do anything. Now after that, there's nothing. It's nobody gave any undertaking. And my lord, there was, my lord, nothing happening. Immediately after, the day when the bench changed, matter went from Justice Sen's division bench to Justice Arijit Banerjee's division bench. Comes a letter. Comes a letter. Then, my lord, we had to rush because I believe it was when Justice Banerjee was in that circuit.
Jalpaiguri.
So he went and mentioned before Justice Boshak, as you take up the matter. They went and mentioned before the Honorable Chief Justice. And then, my lord, we issued a letter that what you are doing, because he immediately started to proceed with this special board meeting. He said, what you are doing is contrary to oral observation of Justice Showman Sen's division bench. So because of the fact that Justice Boshak said, I'm not going to hear. So we went and mentioned before the Honorable Chief Justice that what am I supposed to do? Am I supposed to go to Jalpaiguri? I'm ready to do that. So please indicate. The Honorable Chief Justice said that there's nothing I can do at the present. Let them do what they have to. Now, my lord, in that backdrop, and there is a very, my lord, I'll show your lordship the letter and what we told them at that stage. My lord, please see, my lord, paragraph 6 of this application. This is after your lordship's order. Paragraph 5 is your lordship's order rejecting ad interim relief. Then paragraph 6, being aggrieved and dissatisfied, filed intra-court appeal. Paragraph 7, on appeal was filed on 21st March. Your lordship's order is 20th March. On 21st March itself, next day after your lordship's order, CEO and secretary of the club issued an email to the petitioner calling upon the petitioner to nominate 3 members. On 25th March, appeal was mentioned before their lordships, and when on division bench clearly indicated no steps should be taken till the division bench could take up the matter for consideration. Despite the oral directions as stated above, on 3rd April, CEO and secretary issued an email to nominate 3 gentlemen members. I believe change of determination would be either 1st or 2nd of April. 1st April was the change in determination. Immediately, Justice Banerjee in circuit, me, Millard without a bench, and immediately 3rd letter comes. Immediately thereafter, Millard, please see paragraph 10. On 4th April, plaintiff issued an email stating the then scenario and steps taken by the plaintiff to get the appeal listed and heard. It was stated that until the matter is taken up for consideration for the first time by a division bench, respondent number 1 should desist from taking further steps, especially in view of oral observations. And we issued a letter to the secretary, to the Chief Justice, paragraph 11. Then, Millard, paragraph 12. On 7th April, respondent number 1 through secretary issued an email asking the plaintiff to intimate a convenient date between 23rd April and 26th April so that special board can be intimated and plaintiff is available. 7th April. Again, Millard, within 5-6 days, despite all of this happening, from a reading of the communication dated 9th April, it would be evident that special board has decided to hold its first meeting on 9th April, where the special board would deliberate on the charges. It is thus evident that special board has already met and has held its meeting on 9th April. Then again, 12th April, they have issued a letter to us saying that you have not nominated 3 persons, so therefore, why should we not proceed against you? Then, paragraph 16, special board met.
So what has happened?
No, so after this, Millard, paragraph 18 is the hot haste, Millard, between the time all of this, just when there was no bench, hot haste, and all of this happened. Then, Millard, just when Justice Banerjee came, we mentioned and said, please take it up. His lordship took it up. Now see after that what happens. 24th June is the judgment. The refusal by Justice Banerjee. On 24th June at 7 p.m. we received an email. It must have come on the server at maybe 6 o'clock. At 7 o'clock, there is an email calling upon the petitioner to nominate 3 gentlemen within 24 hours. So, my lord, we filed this application saying Rule 22. That all of this I am ignoring. My lord, I challenge, my lord, constitution of special board, etc., everything. And then, prayer B, I say that this special board, at least till now, could not have acted. So, you constitute a special board afresh and give me that leave to nominate 3 gentlemen members. I'll have to go, I've lost. And I also, my lord, I filed this application and I also took steps for hearing of this petition. So that, because if I succeed here at the interim stage, then my lord, everything goes. Now what happened after this is, when we went before the learned single judge, the learned single judge says nothing doing. You've fixed a special board meeting. I am staying the meeting and directing everyone to informally meet and settle the matter. My lord, we sent Mr. Surana with a letter of apology in the informal meeting. Past presidents also went. And they said that we said that this is the letter of apology, let's finish it. That was, my lord, not accepted. My lord, they said, okay, very well, we'll decide. Then, my lord, that they filed an appeal from that order before the division bench. Division bench said make further efforts. I also met the committee and requested them. And they had come, my lord, pursuant to observations of the division bench. We, my lord, requested that please settle the matter. Now, after all of this, matter comes up again.
Okay.
Now, your lordship will kindly see only one submission I have heard till now. Only one submission. That is, you have consented to the special board from meeting. So, therefore, you are not in a position to prosecute the suit, application. Nothing you can prosecute because now you have to go before the special board. Now, please see the order of the division bench. Order of the division bench. The first order. Division bench's first order. A part of the affidavit in opposition. Page 137. Starts at 134.
Yes.
Prima facie arguments at the ad interim stage rejected by the division bench. Your lordship's order upheld. And paragraph 29, application for interim relief is pending before the learned single judge. Learned single judge directed exchange of affidavits. We are told that affidavits have not yet been exchanged. Your lordship kindly sees this is very important. Because they have no answer on merits. This is all they'll show. We are told the affidavits has not been exchanged. Respondents will be at liberty to file affidavit in opposition within a week, reply week thereafter. Parties may pray for early hearing of interlocutory application before the learned single judge. Appeal and connected applications stand disposed of. No order has to cause.
Which page you are reading?
Miller, page 161, internal page 28. First order.
Yes, you have already pointed out.
Yes. So, this is the first order and paragraph 32.
Correct.
Now, after this, please take the second order of 16th of July.
That is not here.
Miller, 16th July order. That's
The compilation it is page 98.
Yes, 16 July order.
yes. Now, please see, my lord, what was being heard. That order which I told your lordship is the learned single judge granted to enable us to settle on this application GA3, that was being heard. Appeal is directed against an order dated 26 June 25 passed by a learned judge of this court in GA3, which is the application which was on the iPad. Then, my lord, let's ignore. My lord, page 3, upon that application, following order was passed. Then, my lord, secretary of the club has come up by way of this appeal. Then, my lord, please see the last paragraph of page 4.
Yes.
We are of the view that we need not go into those issues. The informal meeting that was held pursuant to the desire of the learned judge has not yielded any positive result. In a sense, the impugned order has worked itself out. Now that the plaintiff himself has applied for an order directing that the special board meeting be held after the board is reconstituted, the parties agree that the following order be made. Accordingly, by consent of parties, we fix 2nd August Saturday as the date and time for holding special board meeting. No further notice, etc. Management will reconstitute the special board. Plaintiff shall nominate 3 members. Club shall make available all papers to the plaintiff and members of the special board. Nothing further, your lordship has seen up to 5, then nothing further remains in this appeal. Appeal and connected applications that disposed of. Learned counsel for the parties rightly say that nothing further remains also in GA number 3 pending before the learned single judge. Accordingly, GA3 is treated as on day's list and is disposed of. GA3 is not iPad application.
Correct.
Then Millard C. Insofar as GA1 is concerned, which is what your lordship is hearing, while disposing of APOT such and such by our order dated 24th June, we have extended the time for exchange of affidavits. The respondents before the learned single judge say that they have already filed their affidavits. Plaintiff shall be at liberty to file his reply in connection with GA1 with a copy. So, GA1 survives. This argument, my lord, that just because you asked for we were oppressing you and you asked for a extension of time to nominate your 3 persons, your GA1, all your arguments go away into thin air. That's not correct. Because by this order, the division bench has extended time for filing reply and for hearing of GA1.
What would be the effect you have given the consent for constitution of the special board?
I'll have, because I have to appear before the special board. I have lost at the ad interim stage in both courts. Now, my lord, I have to appear before the special board. Only way out is one, that I succeed in GA1 and the judgment comes before the special board. It's not happened. So therefore, I am before the special board as I argue. If I succeed in GA1,
if suppose
yes,
special board constituted,
yes,
and adverse taken, decision is taken against
of
you.
course that will happen.
No.
Yes.
Suppose. So what would be effect of this application?
If I succeed,
or you will get the new cause of action.
If I succeed, then Millard.
No, this succeed is different thing. If suppose they today, because it hearing is going on, though I have passed an order not to pass. If suppose if any adverse order is passed, taken a resolution against you and published, what would be effect of this GA1? If they pass the order, then a new cause of action?
No, this will survive even then. Millard, let's see why special board is meeting. 3 steps. Suspension, opportunity to withdraw from membership, then is special board for expulsion. Millard, suspension has 2 stages. First stage is, Millard, ad interim. I have lost both courts.
Correct.
So I have gone to second stage. They told me you withdraw. I said I'm not going to withdraw. Second stage over. Third stage, special board. So, my lord, if, my lord, today before the special board I lose, third stage today, what is happening before the special board today, I will challenge in a fresh proceeding.
Correct, that's what I'm telling.
And but if I succeed here in suspension, then this constitution will be gone. Everything is gone.
Okay.
And I am following your lordship's direction, because your lordship held that special board, you have a right.
Okay.
Just because I can't give up, Otherwise, please see, your lordship directs me that you go appear before special board at ad interim stage. I'm not going to give you an ad interim order. I go appear before special board. Does my interim interim stage become infructuous? No.
Okay. That's all.
That's all. And this sort of victimization, your lordship will kindly will not interfere.
May I start after recess because it's almost recess, so
How much time will take?
I'll have to leave at 2:45. So I'll try to finish. If not, Mr. Mukherjee will. I have to leave at 2:45.
And thereafter, I'm also.
How much time you will take?
13.
How much time you will take? Half an hour. Half an hour.
I will
Submit on behalf of defendant
That-
number 11.
don't take too much time.
That's
I'm
why.
requesting everyone not to.
That's why I'm
trying to
telling. If you all complete by 4, then it will be better.
I will try to convince everyone and request.
Complete by 4 by
Yes, I know
today.
that.
Today 4 o'clock, then it will be better for.
I know that.
If not, then again it is to be
No,
lingering.
what if we want to? This is.
Lingering. इसको ना पेपर में कवर में डालो और सील करो. कवर. हाँ ऐसे पिन करो.
Before rising my lord, out of compelling circumstances, may I, in a commercial matter, my lord, Monday will be 120 days, my lord. I have already taken up an application. Master has given on 6th, my lord, date, my lord. If my lord kindly grants me leave, I can file in the department.
When the 120 days go
Monday,
to
Monday.
Monday. कौन आया नहीं? दे दो. Leave is granted in course of the day.
Yes, in course of the day.
Submit the same in the department subject to acceptance. And I think if they will take, the other matters will not be taken. All advocates may go.
My lord, there is
I was
only
at
one
back-
matter,
I was at number
which
4.
is again, one matter is in the commercial matter. My execution is on number 7. Today, whether it will be done or other.
No,
or
that's why I'm telling no other matters because they are telling that they will take further
several
time.
matters there are. So it may be on Monday.
Yes, it will. See the list when it will.
We have seen the list. My lord, it must be fixed for Monday.
Yes.
I
Item
will
number
cover it.
5.
Item number 7.
7.
And like a tube light, my lord, it, as Lordship sees, it, tube lights not take time to keep flickering and then they light up. Me also takes a little bit of time to register. My lord, after it's registered, my lord, your lordship also said, go before special board. I have also, my lord, thereafter nominated persons before special board. For fixing a date, my lord, I gave consent. That doesn't mean my suit or my application becomes infructuous.
No, not suit, not suit.
Same thing.
Okay.
Same thing. Suit,
Okay, that's I want.
infructuous, both.
That's
Because, yes, but I looked up during the lunchtime, my lord, I looked up. If my conduct is such that by doing that, I have evinced, my lord, a clear intention of giving up my challenge. That's a different
Okay.
matter. Very good.
Thank you. Yes, Mr. Mitra.
May I have my lord's leave?
I will answer my lord's query, but allow me 10 to 15 minutes to say that it's that they cannot approbate and reprobate. Lordship kindly comes to the red book, Rule 22. Rule 22, the red book.
You are for the defined number?
2 and 3, I was.
1, 2, 3.
No, 2. I think it was 2 and 3. 1 to 4. 1 to 4. 1 to 4.
1, 2, 4.
Now, Lordship, yes.
Rule 52.
Rule 22, my lord.
20.
That is the
Yes.
Rule 22, sub-rule B. I will not place the entire thing.
Yes.
It is Rule 22, sub-rule B. That is page 20 of the red book.
Yes.
That is the only provision for calling for the member suspension initially. If it shall be alleged by that any member of any club, of the club has committed a grave breach of any rule or bylaw or has been guilty of any so the class is affected or if the committee is satisfied that a member or any relation of a member enjoying the club facilities under the responsibility of that member has given any monies, gratuities, so and so, the committee may request such member to appear before them at such date, time and place as may be specified, and if the member shall then fail to appear as requested or on appearing shall fail to give explanation acceptable to the committee shall have the following, shall have the power. So it is MRC was an additional protection given to him. As per the rules, only the executive committee. MRC had no power to suspend, had no power to pass any decision.
No, that's why I have 2, 3 questions before we start.
Yes.
See, he has given the letter. It is through WhatsApp to all. And it has been taken in your meeting on 28th of September. On 28th of September.
28th of September at the, yes.
This meeting was taken cognizance by you.
28th of September. 28th September, or Lordship is referring to the 20th September. 28th September, that is the whole thing.
Yes,
that is what the division bench had.
28th September.
28th September AGM. This letter was not taken into cognizance.
No, not letter. That's why.
This WhatsApp was not taken.
No, kindly come to the minutes number 9.
Yes.
You have a copy? AGM minutes number 9.
Lordship has the copy. Lordship is seeing from the
AGM.
From the AGM minutes.
Minutes of the meeting.
Can I give you one? AGM का minutes जो हमको
तो full minutes annex করে দিয়েছি AGM का minutes नहीं कल we've annexed the wrong minute.
If you are not having, kindly see.
No, there is possibly a wrong.
It's annexed as annexure E to our petition, our AO, but we made a wrong annexure. Just give that.
No, that's a which you have given the original one, so I am referring to that.
Kindly give me 1 second. AGM के minutes क्या है? My lord, may I take a look, my lord?
Yes, cute. Take this.
Or may I take up, my lord?
Take this. 9.
9. 19, Lordship is saying.
19?
No,
9.
May I just demeaning, concocted, and misleading? No, this is not the AGM. Is this the AGM? This is the
And yes, 28
executive committee
September.
meeting. Oh, my lord, this is not the AGM. This is
What
the
is
this is the minutes of the committee meeting. Or
Which
will see
meeting?
this is 28 September minutes of the committee meeting.
Executive committee.
Okay, executive committee. Okay, I am not telling. A executive committee. If it is
Sir,
taken by the executive
have that.
committee, yes.
I have that minutes.
If it is taken by the executive committee, so again, what is the necessity by again asking the giving a letter for confirmation within the executive committee on 28 September itself has come to know the Surana has given the letter.
Now, Lordship, kindly sees agenda number,
Yes.
minutes number 9.
Minutes number 9.
The chairman, Mr. Gaurav Chukani, apprised the committee of the WhatsApp message purportedly floated by Mr.
Correct, correct.
I'm saying purported, Lordship, kindly.
Yes,
To the members of the club yesterday, the contents of which were derogatory, so and so and so. The chairman proposed the secretary, Colonel Sanjeev, be tasked for clarification in this regard.
Correct.
From Jai Surana, the decision, the committee expressed surprise and anguish over the same and unanimously approved the proposal as mooted by the president. The committee further directed Colonel Sanjeev, to write a letter to Jai Surana to verify the veracity of the message and inform the committee accordingly. Lordship, this I am telling Lordship from my own experience. Recently, for my son's wedding, my WhatsApp was cloned by the wedding planner, and he was sending all the reminders, messages to all my guests. So today's day and age, it's very much possible for someone WhatsApp message being cloned by somebody else. So we had to verify, Mr. Surana, is this your message? Your WhatsApp, because it's only a WhatsApp message. And this is only a signature. Lordship also sees it, page 254. This seemed like a signature of Jai Surana. Membership number is also not given. So we had to. Otherwise, he may come and say, I never sent this circular WhatsApp. So only for that reason. Okay. So, my lord.
So then kindly again the same meeting.
Yes, my lord.
Again the same meeting. You come on in the same meeting. MRC was constituted. Minute number 4.
Yes, my lord.
Minute number 4.
Minute number 4.
4.
Formation of membership.
Correct. Where is the decision of the executive committee send this request, this case to the MRC?
That lordship has come later.
Yeah, that's I'm telling. This is MRC. Where is the minutes?
18th November, lordship. 18th. Let me. 23rd October. 23rd October. Minutes there. Yes. Yes, my lord.
Yes.
Minute number 13, 23rd October. Discussion on WhatsApp. The CEO and Secretary brought to letter in the form of WhatsApp communication, purportedly by Jai Surana, member and purpose president, CEO. The Secretary placed the reply of Jai Surana, where Surana took objection to verification sought by the CEO. Decision, the committee opined that such averments needed to be examined in detail and Mr. Jai Surana be given the opportunity to explain his averments for proceeding further in the matter.
Okay.
For this, so well, we give the additional chance only.
Okay, no problem. Then the secretary has issued the notice asking where is that power given to the secretary, asking the clarification.
28.
So I am putting the question what they have framed.
I know. 28, Lordship kindly sees that 28 paragraph, that minute number 9. Yes, Lordship will see minute number 9, decision.
No, that's correct. 28 secretary has been given. And this committee was constituted
23rd October.
23rd October. When the secretary has issued the notice?
Yes, October. 23rd October is the MRC.
And when the secretary has issued the notice?
Lordship, the initial notice was given, my lord.
Clarification notice.
That was on 9th October. First letter on 9th October, 9th October, page 255.
9th October.
So he was asked on 28th September and
He replied on 19th saying, I will not answer to you.
yes.
That is when the
So
executive
9th
committee
October.
meeting held.
So after the MRC,
No,
whether-
before MRC. Because had he replied, Lordship, MRC is
It's from January.
23rd October.
Okay, got it. Yes.
MRC, general MRC is constituted.
Okay.
9th
Yes.
October, since he replied on 19th, I will not give you a reply. I'm a past president. Then we said, let the MRC find.
Okay.
Now, Lordship, coming back to the rules, my lord. Lordship, kindly come to the rule 22. Now, we are on 22B Roman 2. So, 22B Roman 2, to suspend such member from use of club for any period not exceeding 3 months. And Roman 3, where a member is suspended as above, to call upon such member to resign from the club.
Yes.
Next, well, at this point, that was what was done before he came to court.
Yes.
That was done on the 30th of January. The suspension was made, and 6th of February, the secretary wrote to him, would you like to resign?
No, 30th only. Both.
Oh, 30th only.
30th,
Same day. Now, my lord, so since he did not want to resign, so it goes to C now. If having been called upon to resign as above, the member concerned shall not do so within 24 hours thereafter, the committee may refer the matter to the special board for decision as to the expulsion or otherwise of the member.
Yes.
So, and now the special board kindly comes straight away to 22I. Constitution, special board meeting, special board will fix a date, then 22I. The special board shall arrive at their decisions by majority, either by show of hand or by secret ballot, as the chairman may determine. And the special board shall have the power to confirm, set aside, or vary the decision of the committee.
Correct.
Or expel. So, Lordship, it was at this stage he came to court, and it was being decided by my lords whether it will be decided by special board as per the rules, or the court will decide on the suspension.
Okay.
The division bench here has reiterated what my lord has said. Where is the compilation of orders? What compilation now? Now, Lordship has got the compilation of judgments. Lordship, kindly come to the division bench, which starts at page 24th June order, which starts at page 62. Kindly come to paragraph number 23 at page 78. Page 78, para 24. 24 first.
Yes.
The rules of a social club constitute a contract between the club and its members, and has its members all the members are bound by the rules. If the rules provide for suspension and or expulsion, a member may be suspended or expelled following such rules as observed by the Honorable Supreme Court in Lodge Victoria. The role of a civil court in resolution of a dispute between a club and its member or members is inter se very limited. The court cannot sit in appeal over a decision of the executive committee or governing body of a club. The court can at the highest set aside such a decision if it has been taken in good faith. So this was the court's finding, that the special board should be allowed to take its decision.
Yes.
Now they have the audacity to then go to the learned single judge, make an application. Go to the single judge. Now kindly come to page 90. Make an application for constitution and then persuade the court. Now, whatever they may say, passing the buck on the court, that the court did on its own, the court does nothing on its own. Kindly come to page 94. they persuade the court to stall the special board meeting. 94, third paragraph. Second paragraph.
94.
4. 90, 90 it starts at 94.
Yes, second paragraph. In the
In the
aforesaid
to enable amicable resolution of the dispute to materialize, this court feels that instead of holding a special board meeting, the same should be adjourned, and instead that at the same time and venue, an informal meeting may be held nowhere in the rules between the president, the members of the executive committee, and the plaintiff. So, and this is followed by another order passed next day, page 96. At page 97, by the time we had moved the appeal, it was going to be listed one day thereafter.
Yes.
97, last paragraph. It is expected that till there is any direction from the appellate court, the party should maintain status quo as on 28th of June. Needless to mention that the avenue for amicable settlement remains open to the parties. Now, Lordship kindly comes to page 98. When we come up in appeal, kindly come straight away to page 101. 101. After the quotation being agreed, then the next paragraph.
This is a division bench order.
The division bench order. This is in their second application, GA3 for Constitutional Special Committee,
Yes.
Special Board.
Yes.
101. Second, after quotation, it was submitted on behalf of the appellant that the learned judge ought not to have in effect stayed the holding of the special board meeting scheduled to be held on 28th of June. That runs counter to the judgment and order of 24th of June passed by the division bench. At that point, they don't support the order at all. They hijack it. 101, next paragraph. They say, I did not ask for it. We are of the view that we need not go into those issues. The informal meeting that was held pursuant to the desire of the third judge has not yielded any positive result. In a sense, the impugned order has worked itself out. Now that the plaintiff himself has applied for an order directing that the special board be held, the parties agree. Mr. Banerjee was also there. That the following order may be passed. Mr. Chaudhary, Mr. Ratnanku Banerjee, client, everybody was there. Accordingly, by consent of the parties, the following order is made.
Yes.
So this was the direction, and here we fixed the meeting on 2nd August, 11:30 a.m. as the time and date, as the date and time for holding the special board. No further notice of the meeting shall be issued to the parties. Appellant will ensure that all concerned who are not present before us receive adequate notice, so all the past precedents. The management of the club shall reconstitute the special board in accordance with 22D of the rules and bylaws. The respondent plaintiff shall nominate 3 members of the club, represent, etc., etc. And nowhere is it said here that this is going to abide by the result of GA1. Earlier order was said. Now, Lordship, they have not told you one thing. They have the audacity. Next day, they serve us with an application being GA4. They had filed it earlier, they never served us. This is GA4. GA5 takiye. GA4, kindly see what prayers they see. GA4. After the division bench order, I'm going to copy it. Copy it. GA5 क्या है?
আমাদের order send করলাম
GA4 prayers देखो. And they asked for Rule 22 to be stayed. Kindly see this.
An order allowing the amendment of the present print.
And as you go down, there's one of the order D or E. Stay the Rule 22.
Stay the proceeding in accordance with Rule 22. So what is the status of this?
So they moved this 2 days after. Kindly come to page 105 of the compilation. And they press the application. This is the division bench passes the order on the 16th of July and 18th of July. They move this application. Lordship, page 10. page 106. No, sorry. 107, that's a mistake. 107. 23rd July. In application for amendment of the plaintiff, the defendants object to the nature and character of the amendment sought for, contending that the same will alter the nature and character that we object. The said amendment is the teeth of an order passed by the division bench, giving rise to violation of such order. Without prejudice to such submission, let
Page
at
number.
page 107, second last page, 107 of the compilation.
GA4. Yes.
GA4.
Characters for the summary amendment.
They were asking, they were pressing this application.
Yes.
Luckily, no stay is granted of Rule 22 proceedings. And then immediately they said, now here out. Now, Lordship, I am on before. I am on the. When you agree before a court, when it's a consent order, there is no res judicata doesn't apply. Then it's a case of estoppel by conduct. And the courts have seriously looked down, has seriously taken exception to anyone agreeing before one court, one course of action, and then the judgment reported in 1810, I think it must be in the compilation because I had cited before the learned single judge, loose copy article 1810 SCC and 2003. दोटो है तो दोटो दो है 1810 SCC and 2003. I have got one more. I have got the extra set.
Yes. 2018-10 SC 707.
707 Suzuki Parasram.
Suzuki Parasram.
Lordship kindly comes to paragraph 10. 711. The appellant initially took a conscious and considered stand before the company judge, staking a claim for being substituted as a secured creditor under SARFAESI Act, consequent to assignment of debt to it by IFCF. That the claim was not simply with regard to assignment of an actionable claim under 130 of the TP Act is evident from its own pleadings and the proceedings filed by IFCI before DRT. No material has been placed before us with regard to the orders that may have been passed by the tribunal on such application. After the claim of the appellant of being a secured creditor was rejected by the company judge, the appellant realized the unsustainability of its claim in the law. It made a complete volte-face from its earlier stand, and surprisingly, contrary to its own pleadings, now contended that it had never sought the status of a secured creditor. The contention of the appellant that it had never sought substitution as secured creditor under SARFAESI Act is additionally belied by the recitals contained in the order of 7 September 2015. Time and again, this court has held that recitals of the order sheet with regard to what transpired before the High Court are sacrosanct. The learned single judge in the review jurisdiction has reiterated that the arguments addressed before him in company application number 248 were made specifically under the SARFAESI Act, observing as follows. I'm not reading the quotation. A litigant can take different stands at different times, but cannot take contradictory stands in the same case. A party cannot be permitted to approbate and reprobate on the same facts and take inconsistent shifting stands. The untenability of an inconsistent stand in the same case was considered in Amar Singh and so and so. He, having agreed to this at no stage of the suit, even whatever stage, he can never say that the decision-making process now will be not that of the special board, but that of the court. Because he has agreed that the special board will now take a decision under Rule 22I. Now, just take a situation. Your lordship holds that the suspension is good. if Lordship still holds on the merits. Special board holds, suspension is bad.
Like,
So what will happen? So will the special board's decision fail? Will there be a competition? Lordship will decide, and special board will decide.
that's why in the first morning I told let me stop for giving the effect. Now tell me what would be the effect if suppose to you taken the decision and the court is hearing the GA1.
GA1, there are other prayers which he has not pressed for. There are other prayers for the show. Other prayers are there. So, but then he has not pressed those prayers. So, I am not troubling.
No, he has not pressed any further.
So there are other prayers which he has not pressed. So, those could have been pressed. If he was otherwise entitled to, for example, prayer C. So this. की prayer there. This prayer, of course, is beyond the scope of the suit. Lordship will find the suit prayers are at page 67 of the application, but this is the prayer.
Okay.
So, this application still remains. He has not pressed it, rightly not pressed it because this is not in aid of the reliefs. But this prayer is gone from him. He cannot. Just one more judgment. This is really my first and my principal point. This is abuse of process going on. With all the respect, had he not been an advocate, I would have seriously pressed for costs in this matter. But one more judgment, 2003, 8 SC, but he's a fellow advocate. Certainly, I will never press that. Page 6 at page 692. Paragraph 65. The decision-making process shifts to the special board as the rules contemplate. Okay, paragraph 65, second line. He should either stand by his statement made before a court of law or should explain the same sufficiently. In absence of any satisfactory explanation, the court will presume that the statement before a court is correct and binding on the party on whose behalf the same was made.
Yes.
So while I am taking strong exception and then spending so much of my court's valuable time on a thing which he has agreed through his senior before the division bench. Now, Lordship, just a few briefly I will take my lord, since he has taken these points. These are all covered by my lord's whatever issue he has raised today. Assuming he can take it in a proceeding of this nature. Lordship, disciplinary proceeding will be decided by the court. Lordship kindly takes my lord's judgment first. My lord's judgment, which is a compilation, page 20. 13th March. 13th March. Krishna judgment. No, 20th March. So, page 22. 22 of the compilation. Kindly come to internal page 29. Sorry, paragraph 44. That is 27 internal, page 48.
Page 49.
Page 48, 49, yes. Yes, that is there. In the present case, the circulation of WhatsApp message by a plaintiff, notices were issued to the plaintiff for confirmation whether the said circular was sent by the plaintiff or not. To give an opportunity to the plaintiff, the members' relationship committee was formed. The said committee has given personal hearing to the plaintiff. After the said meeting, 3 queries were made to the plaintiff. But the plaintiff has not answered to the said queries in spite of several opportunities. Executive committee also gave an opportunity to the plaintiff to explain the basis of the allegation in its meeting on 27th of August. But in the said meeting, also the plaintiff has not explained and again asked for the minutes of the 8th November meeting, though by an email 25th November was informed to the plaintiff that the meeting was videographed with the concurrence of the plaintiff and the videography should be treated as the minutes of the meeting. In spite of several opportunities, the plaintiff failed to answer the queries. Accordingly, the defendants have issued the impugned order of suspension. invoking Rule 22B. The plaintiff is placed under suspension and also called upon to resign from the club as member under Rule 22B3. As per Rule 22C, if the member concerned shall not do so within 24 hours thereafter, the committee may refer the matter to the special board for decision as to the expulsion or otherwise by the member. In terms of 22D, the plaintiff is also entitled to nominate his 3 gentlemen members and then permanent members. As per the provisions of 22G, the special board shall inquire into the matter. The plaintiff will again get an opportunity to explain his grievances before the special board. After hearing the plaintiff's grievances, the special board will take appropriate decision. The cases relied upon by the plaintiff are connected with blacklisting, and there is no quarrel on the proposition that it is mandatory requirement to give show cause notice for blacklisting. In the case of the plaintiff is of suspension pending inquiry, the plaintiff will get an opportunity to place his grievances before the special board. Thus, there is no necessity to issue show cause notice. Now, Lordship kindly sees the division bench has confirmed this, and since he's trying his luck, there are some more findings against him. Kindly come to page 72. And see, Lordship did not comment on the quality of the WhatsApp message, but since it persuaded, page 72, paragraph 19. Division bench judgment.
Yes.
We are paragraph 19. We are prima facie of the view that there was no good reason or justification for the plaintiff to circulate the concerned message amongst the members of the club on 23rd September. The plaintiff had already written a letter on 20th September raising queries about the accounts of the club. Our attention was not drawn to this letter by the plaintiff. In our opinion, this letter is very material. The issues indicated by the plaintiff in his message circulated on 23rd September could easily have been concluded in his letter of 20th September. We deem it appropriate to reproduce the message from that the plaintiff circulated on 23rd September 24. The message reads thus. This is quoted, and then page 74, paragraph 20. Prima facie, the aforesaid message imputes lack of honesty to the persons in control and management of the affairs of the club, primarily the executive committee members. Financial irregularities have been alleged, calling in question the integrity of the persons in management of the club. It would have been an entirely different thing if the grievance sought to be ventilated by the plaintiff by circulating said message was ventilated in letter of 20th September, as he was entitled to do under the rules of the club. May I pause here for a moment? He was saying this rule 20, this 7 days to give reply. Kindly see that notice which is at page that notice of the AGM where this was. AGM notice is at page 202. Kindly see page 202. 202, volume 2. I think so. That ভুল বলছি আমি এখানে 202 লেখা আছে কেন 209 sorry 209 209 নয়
Yes, 209. That is agenda. Agenda communicated in the last.
209 at agenda 5 within brackets. These points must be submitted in writing to consider or transact any business or to be. These points can be submitted in writing to the undersigned on or before 20th September. No other question, discussion, resolution may take place. And at the footnote is also to facilitate the members give a reply by 12th September. He is a past president of the club. He's saying this was never done. Kindly see when he was the president. See the notice. I have only one book. Kindly see the first page. Agenda 5. Number 5. Give it by a certain date. Same thing happened. This is extremely unfortunate, not becoming our gentleman's club. And we just quietly listened to all the abuses against the present committee members. And see that the president's name, previous page. Every year this has happened.
Yes.
Now coming back to what I was placing, paragraph 20, page 74. Last 4 lines. All such issues could then have been discussed at the AGM if this was given. The tenor of the message in question tends to indicate prima facie that the plaintiff has circulated the message to disgrace or malign the office bearers of the club, including the members of the club. We are prima facie of the view if the plaintiff had any bona fide concern about the affairs of the club. He should have discussed the matter directly with the office bearers of the club. He can still do so. After all, it is a social club where the members go to relax, for entertainment and to entertain guests. There should be camaraderie amongst the members of a club. Ill feeling or animosity should not have any place amongst them. A member like the plaintiff has genuine grievance as regards any aspect of the club. He should take it up personally with the person running the club or place it before the general body. Following the rules and regulations, the course adopted by the prima facie does not meet with our approval. And then comes paragraph 23 at page 77. We therefore find that the special board contemplated under the said rule would not only have all past presidents of the club who are present in Kolkata, 19 in number as of now, as we are told, it should be 29. But also 3 members nominated by the plaintiff if he so wishes. There will be 3 members nominated by the committee and also the president or the vice president of the club. Even if one were to assume, and we do not see any reason for such assumption, that the president, vice president, or the 3 members of the committee nominated by the committee shall be unbiased. The other members of the special board should be presumed to be impartial. All the past presidents are now from the 1970s, they are still there. And they are the majority. Therefore, the dispute between the plaintiff and the club will almost certainly be considered and decided by the special board fairly dispassionately and in an unbiased manner. And then paragraph 24 I had placed only the decision, if it's taken contrary to natural justice or in bad faith, it can be challenged. And then Lordship. Now Lordship kindly come to page 86. After all the judgments which was placed before my lord, including that Suresh J said at page 85, at 86. Observance of the principles of natural justice does not necessarily mean the written show cause. Exactly what my lord has said. Written show cause has to be issued to a person against whom action is proposed to be taken. Granting an opportunity of hearing should be enough in many cases. Prima facie, we find that in the present case, the plaintiff was given opportunity of hearing, not only by the MRC, but also by the executive committee. Therefore, prima facie, we do not find violation of audio alternate partum in this case. Therefore, prima facie, we do not find the suspension of the plaintiff to be bad, or dehouse the club rules, or in breach of principles of natural justice. We have noted the decisions cited on behalf of the appellant plaintiff on the point of natural justice. However, such decisions do not help the appellant in the facts of the case. And then Suresh J said that the Bombay High Court has been extensively distinguished. Paragraph 27.
Yes.
And then my lord's order is quoted from paragraph 44, what I just now placed also, and then paragraph 28. Well, what has happened thereafter? What have they shown thereafter? They have, I've been hearing on and off Mr. Chaudhary submitting these minutes are fabricated minutes. Look for it in the petition, look for the affidavit in reply. Nowhere have they taken the point of fabrication.
Yes.
Fabricated minutes, nowhere. Let him show where he has taken this point in the pleadings. So this is the position, and since they were talking about this motion, since they had placed volume, the order Justice Bhattacharya, now take out that Shubhagachi. This man is driving the club up the wall. Justice Bhattacharya's order was page 154, volume 2 was relied upon by Mr. Chaudhary. When Judge ran up election rules, there was no e-voting. So this was general meeting. This was nobody challenged the order. Page 154. Mr. Jay Surana had come to court and he got the e-voting undone. What he has done, through his father-in-law, he proposes a candidate. Through his father-in-law, he proposes a candidate, not to kindly see, for the election AGM, which was scheduled to be held on Saturday, 6th of May or 5th July.
Saturday,
6th July. The gentleman whose name, which is the name?
Petitioner.
Petitioner. Naam tak ye ekhane konte. Gulab Mal Singhvi. Shahim Imam Sardar. Through him, filed the suit. Saturday is the morning is the AGM election. This gentleman files a suit on Friday and Saturday morning, 10 o'clock, the AGM is at 11 o'clock, serves us with an injunction order, ex parte. We move the appeal, we have to move. So the AGM falls flat, couldn't be held. We came up in appeal. Phone niye ব্যস্ত, where's the other order?
এই যে আমার order
ঠিক আছে।
একটা copy আছে।
জজ সাহেব দাও, আমার কাছে আছে। আমার কাছে আছে। আমার কাছে। I've got. Horseshoe kindly comes to the every point. This was then order was really set aside. Horseshoe kindly comes to from paragraph 40, from paragraph 35 on. And we've been allowed to conduct the meeting strictly as per the rules and regulations. The whole 200 people landed up at the AGM. NSDL was engaged for conducting the AGM at a high fee so that there can be no imputation, e-voting. The same advocate on record also is there.
Yes.
And now they are now contesting once more for the Learned City Civil Court to stall the next AGM. Whatever will happen, will happen. Well, this is the way. So my humble submission is that I'm not asking for cost.
So this Sardar Sahim is one of the member.
Who was proposed by this plaintiff's father-in-law. That's why I've given the name. And he stood for elections, a candidate for the committee. The second proposer or second is Ghulam Mal Singhvi.
Yes. Ghulam Mali Singhvi.
And through him, he files the suit, gets an AGM stopped. Like he was saying that earlier suit, Bhattacharya's time also, the same set of people were doing mischief. That's why I'm. Oh, yes. And before the, yes, well, before the division bench, just before this plaintiff in the first round of appeal made an application for staying the AGM. Division bench did not pass any order. So he gets this candidate to file a suit and get an injunction. And now the whole thing is set back. The meeting is scheduled on 10th of August. From where he'll get some order, I do not know. One does not. So this is the position. Well, I don't think I need to go in any further into the merits of the case because everything is it's settled and this is okay. Yes, well, Chandar Kochar. I should kindly see one thing. This Chandar Kochar's committee Lordship report, he gets the notice of the AGM on 12th September 2024. He gives a questionnaire on 20th September. 23rd September, he gives this WhatsApp pointing out figures. Where does he get all this? His report, this Chandar Kochar report, this Chandar Kochar. Khator's not ICICI Bank. Khator's report on 30th of or 1st of October. So how did he get all these allegations on 23rd September WhatsApp? He gets this report. Last page. And Lordship, I just want to show something very, very attractive, so I can't resist. My juniors point out. Kindly come to the last page of the report, page 245.
245.
Disclaimer, how can he do this? The observations have been given on requirement and for the expressed use of Mr. Jai Surana, past president of the Calcutta Swimming Club, and is meant for him only. Any reproduction, distribution, or use of this report or its contents without any written permission or consent is strictly prohibited. CK is not responsible for any matter concluded with a third party based on the contents of this report. And he circulates and he makes this part of the. And he could have included this. He could have given this on at the AGM. How? AGM was also before this report. Report came on 1st of October. AGM was on 28th. Why could he not get this report and place it? Queries before the AGM.
Yes.
Rule 51, Mr. Chaudhary had relied upon, page 38. Before the committee also, it was the first time you see it here. Rule 51, page 38. The minutes of and Rule 51, page 38. The minutes of and
yes,
the resolutions passed at each meeting of the committee and at each general meeting of the club shall be fairly copied in a book and signed by the secretary and the chairman of each meeting. The minutes of the annual general meeting shall be open to inspection by all members because that's a members' meeting. Committee meetings are not open to inspection by members. That we have produced to the court whenever Lordship has required us to. So only the AGM minutes is very much there. There's no grievance that AGM minutes is not available for inspection of all. Yes, in fact, your Lordship has at para 38, Lordship has specifically dealt with this Rule 28. Rule 51. Well, that I will not trouble my Lord. I will not.
Thank you.
I'm very grateful to Master. If your Lordship so desires, if it's of any help, you can give a list of dates to my Lord with the correct page number. I will. Very grateful.
Thank you.
I'm requesting everyone not to take up.
Yes. So, Bhattacharya, you are appearing for?
Number 5. First,
Yes.
First submission to your lordship is, in a suit of this nature, the conduct of a litigant is very important. Whoever is coming to court, with a prayer for ad interim or, interim relief, has to come with a case which is, a case which stands at the highest, entitling him to relief. One has to come apart from the usual, principles on the grant of injunction and or refusal thereof. First submission to your lordship is, in the facts of this particular case, the matter travelled at the ad interim stage without affidavits, before a honourable single judge of this honourable court. Incidentally, it is your lordship. After a considerable length of hearing, an order was made by your lordship, disinclined to grant him ad interim relief at that stage. The honourable division bench was approached. The honourable division bench, only on the question of whether interim relief was supposed to be granted or not, has made certain observations. Which inter alia, I adopt completely the submissions of Mr. Mitro. Please see the observations of the honourable division bench in paragraph 24 and 26 in particular. Prima facie, the honourable division bench felt that audi alteram partem was resorted to. Prima facie. Now, that prima facie observation cannot, be set at naught, even at the final hearing, on affidavits, because, factually, audi alteram partem was resorted to is the prima facie finding of the honourable division bench. Apart from that, the honourable division bench has recorded in paragraph 24 of the honourable division bench's order. Please see paragraph 24. Order and compilation. Kindly sees. Page 78. Here, I am told, Mr. Mehta, who is also appearing for one of the parties, has raised a very pertinent issue. The rules of a social club constitutes a contract between the club and its members, and has also the members' inter se. All the members are bound by the rules. Pausing here for a moment. I go, since essentially, I practice in the Article 226 side and service matters. Kindly visualize. As an employer has a right to refuse employment to a particular employee. Here, that is also contract. And in the sense of a specific relief act, a contract for personal service is not specifically enforceable. Here is a club. The members, good, bad, indifferent, is bound by the rules of the club. If the member seeks to deviate from the rules, violate any of the rules, then in my most respectful submission, steps prescribed in the rules and bylaws as contemplated in Rule 22 can be resorted to. And that is precisely what has been done. And, a lot of submissions have been made. A conduct of a litigant also has to be looked into. He, after, the Honourable Division Bench pronounced the judgment on the 24th of June 2025, relegating the main issue back on affidavits, GA1, he takes out applications. As I am informed, GA2 not pressed. GA2 Not there, my lord. He wanted to move GA2. He was not allowed. GA3.
What is a GA2?
My lord, this is another application.
G2 was their
Before the
application.
division bench.
G2 before the division.
Yes, my lord, I stand corrected. He takes out the present application at some stage. What stage? GA3 is his application. My lord, the praise of GA3 are quoted in the subsequent division bench's judgment. If your lordship sees, my lord, page 98, kindly sees page 99.
Yes.
Let's kindly sees prayer B.
Correct.
Prayer B, prayer C, all in the nature of constituting the special board afresh.
22B. Yes.
Now, we are pausing here for a moment. Having invited the court to go into, he somehow persuades the Honorable Singh, the coordinate bench, to make a via media solution, if it can be resolved. Milord, that attempt was made. The Honorable Judge, Milord, directed, Milord, if some course can be adopted, we carry an appeal from the order. The Honorable Division Bench records a consent order. Milord, I put this question to myself. Today, had it been any other litigant, Milord, your lordships would not have permitted a litigant to file even one application from a consent order. Even one application from an order passed on consent of the parties. Milord, consent presupposes both parties are ad idem.
Yes.
And therefore, Milord, whatever application is being sought to be moved, despite the fact GH3 has been disposed of, the only endeavor today before your lordship and all this entire week since we entered appearance, Milord, on the 30th of July, the entire week, the only attempt was to stall today's special GM. Nothing else. Because either, Milord, as Mr. Mitter was submitting, Milord, it may be so that the special GM comes to his rescue. Then what happens?
Yes.
They may be persuaded. But why is he so apprehensive? He himself invites an order, and thereafter, Milord, he wants to stall, he wants to do everything, he wants to implore your lordship to pass an order or at least request us not to give any effect to the order. Milord, I put this question to myself, is he even entitled to that? As a litigant, one should be fair and clear to the court, whoever and how highsoever he or she might be.
Yes. Yes.
See, his rights are affected. His rights are in this book. Whatever is there, he is bound by it if he is a member, if he considers himself to be a member. Milord, a lot of submission was being made regarding that report. Milord, please see that red book once again. Yes, Milord, I am grateful to my learned friends. Milord, members bound by the rules and bylaws. This is a part of rule and part of rule 23. After 22, kindly sees, Milord, 22I at page, Milord, 22,
Yes.
Milord, 23. Now, Milord, that being the position, Milord, submissions have been made by relying on page 245.
Yes.
Milord, this Chandar Khator. Milord, Chandar Khator, first of all, Milord, my limited understanding of the subject, Milord, observations on review of annual report. Milord, I put this question to myself, Milord, who asked Chandar Khator to give a review of the report? Milord, it is addressed to none other than a past president. Please see page 228 of the application.
Yes.
It's a past president. Milord, I put this again to myself. Milord, please
No,
see.
they have admitted that they have obtained the report. It is
Yes,
not, yes.
Milord, if today, Milord, at best, the rules also prescribe, Milord, rule 46. Kindly see. It is a conclusive thing when passed by the AGM, by the general meeting. all audited accounts when passed by a general meeting shall be conclusive.
Yes.
Error discovered. Who has discovered what error? I only take the help of some outside, some outsider, someone not related to the club, someone whom the club has not appointed, and get a report in my favor. I have appointed him, he is going to give a report in my favor. It's like, our, with all humility and respect, my lord was also on this side. Some time back, I also had the occasion to appear against your lordship. The issue is, please bear with us. We on our own, have our own, accountants and, at times chartered accountants, at times, income tax. They give something which suits our convenience and balances the show.
Correct.
And this is one such incident. On this basis, can any conclusive material be placed or relied by anyone to suggest that the accounts is not maintained properly?
Okay.
Next submission to your lordship is, in one of the reliefs prayed for in the instant application GA, he has not pressed this. Prayer C.
Yes.
He has not pressed this, but I take it, the prayer exists. So appointed to appoint a reputed firm.
Yes.
Question is why? Just because he feels so. He has the he has such a goodwill. He has circulated WhatsApp messages instead of directly approaching any particular person with any of the grievances that he perhaps had. He did not choose to do so. He maligns the club, and the club very rightly, in my most respectful submission, takes resort to Rule 22. Because for any breach of rules, until the next, if he has committed a grave breach or has been guilty or responsible for any conduct, his actions, by showing your lordship, as very correctly pointed out by esteemed senior, there is no whisper. To the best of my knowledge, I'll stand corrected by Mr. Sarkar. To the best of my knowledge, there is no pleading anywhere regarding the correctness of the minutes. He wants to import something which does not exist.
Okay. Yes.
He wants to impute allegations on persons, for no known fault committed by anyone. Whatever was done, he triggered the entire thing. If I may say it in this way, the entire trigger was by him, not by anyone else. He triggered, he sent WhatsApp messages and communications to everyone, and ultimately the resultant effect is resort to Rule 22.
Correct.
There cannot be any infirmity in the entire process. In a proceeding under Article 226, the parameters are different. But even at the stage of grant or refusal of injunction, a conduct of a party, the conduct and his various tactics adopted in course of the proceedings also perhaps does not entitle a person to relief. Now, I will be humbly tempted to cite only one judgment in this regard. 2020 volume 2 SCC page 52.
You're for the defendant 5, no?
5. 52. Here in paragraph 17, your lordship will be pleased to. I remember, this 2020 volume 2, therefore I have brought it. Paragraph 17 is a quotation which has been affirmed once again in 2020 volume 2, page. Please see page 62.
Yes.
If the primary fact, K.D. Sharma is quoted. I am relying heavily on this,
Yes.
If the primary object as highlighted in Kensington income tax is kept in mind, an applicant who does not come with candid facts and clean breast cannot hold a writ of court, kindly ignores it, cannot hold a court. with soiled hands. Suppression or concealment of facts is not an advocacy. It is a jugglery, manipulation, maneuvering, or misrepresentation which has no place in equitable and prerogative jurisdictions. My lord, injunction is also an equitable relief. If the applicant does not disclose all the material facts, my lord, has my learned friend disclosed? Subject to correction, my lord, his application being GA5. He has not disclosed.
Your application.
GA4,
GA4.
GA4.
GA4. Whatever it is, my lord, he has not. He has prayed for an amendment of the plaint. That is his prayer sought for in that application. Disclose all the facts fairly and truly, but states them in a distorted manner and misleads the court. The court has inherent powers in order to protect itself and to prevent an abuse of its process to discharge the rule nisi and refuse to proceed further with the examination on the case or merits. My lord, here your lordship is looking at a litigant who, before the division bench, concedes to a particular situation, concedes to a meeting and a date fixed for that meeting, and thereafter, my lord, approaches a court, takes, my lord, the entirety of days before the court. He has a right as a litigant, but, my lord, had it been anyone else with a consent order, could he even imagine to persuade the court to hold otherwise?
Yes.
My lord, I rest my case at that, my lord. The defendant number 5, apart from this, my lord, categorically adopts, my lord, whatever the submissions of the respondent, defendant number 1.
Thank you. Thank you for the brief here. Yes. Yes, you are appearing for
I'm taking a lot.
Defendant number 11, Miller. I'll be very short, Miller. I think nothing much, Miller, left for me to Miller to.
Who are you? Member?
Member. Now, Miller.
Number?
11. Now, Miller, the issue is very clear. Now, Miller, Miller has passed an order on 20th March, which was carried to appeal. Now, Miller, everything must be, Miller, maybe prima facie. But, Miller, kindly, Miller, see the compilation of the Miller judgments, Miller, at page 72, paragraph 19 of the division bench order, where, Miller, the honorable division bench records, Miller, the suppression of by the plaintiff. Now, Miller, I will not take much time. Miller, the division bench has recorded the suppression, and Miller, I rely on the judgment, Miller, referred to, Miller, by Mr. Bhattacharya, Miller, just now before your lordship on this issue. Now, Miller, kindly comes to, Miller, paragraph 21, 75, page 75.
Yes.
We are prima facie of the view that if the plaintiff had any bona fide concern about the affairs of the club, he should have discussed the matter directly with the office bearers of the club, and Miller, he rests on, Miller, the internal management. Now, Miller, this is no more, Miller, res integra. The law is well settled. Miller, there had been, this not the, as if this is the first matter. There has been Calcutta club, there has been, Miller, Bengal club, there has been Saturday club, there has been Cosmopolitan club, there is Vivekananda Sporting Club. All judgments are there. Miller, the law is, Miller, very much well settled. Internal mechanism, court should not interfere. Then, Miller, no, our civil, Miller, club cannot proceed. Now, Miller, I will be relying on, Miller, paragraph 23. Just, Miller, 23, 24 at page 77 and 78.
Yes.
Now, Miller, 26 at page 86.
Yes.
And now, and Miller, at last, Miller, 28 and 29. So, Miller, these are the observation which still remains.
Yes.
And, Miller, there has been no change in situation or circumstance. If that remains, Miller, the observation remains, Miller, no appeal has been carried out, and this has reached a finality.
Yes.
Now, Miller, by consent of the parties, Miller, August 2 meeting was fixed. There cannot be neither no appeal can lie, no application can lie after, Miller, the consent has been given. Now, Miller, rest, Miller, I, Miller, refer, Miller, adopt, Miller, the submissions of, Miller, Mr. Mitro and, Miller, Mr. Bhattacharya. Now, Miller, I will, Miller, hurriedly, Miller, refer to, Miller, few judgments. Milad 2005 SCC online SC 1786 paragraph 3. Milad 3 paragraph judgment, but milad it said milad said the law paragraph 3.
Your defendant 11, na?
Even number 11.
Yes.
It has made the law very clear. Kindly see paragraph 3. 3 paragraphs, only 3. Kindly see paragraph. In the matter of disputes relating to clubs, ordinarily civil courts do not interfere and the dispute should be left to the adjudicator upon by the internal mechanism provided by the constitution of the club. So if I am a member of the club, I am bound by that red book. And if I have any allegations, anything to be milad, I should go before the milad, the office bearer, and milad the mechanism provided by the club. Now milad the next judgment is of milad 2011 13 SCC 774.
Yes.
Yes. Milad kindly comes to paragraph 52. At page 793. At the
Yes.
I will be referring to one paragraph only. In the matters of internal management of an association, the courts normally do not interfere, leaving it open to the association and its members to frame a particular bylaw, the rule or regulation which may provide for eligibility and or qualification for the membership and providing for limitation, restriction on the exercise of the right by a member on the said association. It is well settled legal provision that once a person becomes a member of the association, such person loses his individuality qua the association. This is very important. So you are bound by the rules and regulations. I am a member of Bal Library Club. I am bound by its rules and regulations. Similar, the issue is this was though against Supreme SCBA. So the issue is no more left to be agitated. Now the next judgment is of Supreme Court of 1963 AIR 1963 Supreme Court 1144.
Yes.
Paragraph 8.
Yes.
Kindly see the 4 lines from the half part of the paragraph 8. The jurisdiction of a civil court is rather limited. It cannot obviously sit as a court of appeal from the decisions of such a body. It can set aside the order of such a body if the said acts without jurisdiction or does not act in good faith. And violations of principle of natural justice. This has been set in this matter, Audit alternate part time at paragraph 26 of the division bench. It has been put to rest by your lordship, upheld by the honorable division bench. So and this judgment has also been placed before the honorable division bench. I can just kind mark the division bench yes. It is at page page 67 of the compilation of judgments. My lord will find division bench has relied on this of the page 67 of the compilation. Internal page 6 of that judgment.
Yes.
And on the basis of that, the order was passed.
Yes.
Delhi High Court, after Supreme Court, the Delhi High Court single bench judgment, 2023 SCC online Delhi 2703. Give me a moment. But 46 and 47, the 69 भी है. Anyway, my lord, I'm not getting the Millet paragraphs. Very well. Sorry. 46 and 47. I was going through the Millet 67. AIS. 46 and 47.
Yes.
47. Now, these are the 4 judgments. Now, Millet, Mr. Chaudhary, Lanet Senior, had Millet said that meeting has been called in Millet 11 a.m., 12 a.m., 12 p.m. Well, can a Millet member cannot visit the club at 12 a.m. in the morning, 11 a.m. in the morning, 12 p.m. in the morning, in the afternoon? Is there any bar? Millet, may I put the question to myself? Millet visits Calcutta club, Millet find Calcutta club full at 11 a.m. There is no bar.
Okay.
Millet, these are my submissions. Millet, I will not Millet bother your lordships. Millet. They adopted.
Yes.
Lord, I am the last of the respondent side, Lord.
You are appearing for?
I am appearing for the respondent number 13.
Yes.
Well, the plaintiff filed the suit claiming breach of the natural justice, and thereafter the interim orders were passed and the matters have gone through, and thereafter, my lord, on 12th of April 25, a so-called notice was issued for the revocation of this. So, my lord, and there is a direction for adjudication by the board, my lord. Thereafter, my lord, nothing survives in the suit because the breach of the natural justice eliminates after the so-called notice is served to him. Formally, all documents, there is no complaint now that relied upon documents, etc., are not given, etc. Adjudicating authority is board. So, my lord, the showing wrong account here is no meaning because it's or should be shown before the authority who is to decide. So, my lord, so that authority is now decided, and the in purpose of that suit has now become infructuous. Suit has become infructuous. The second point is this, my lord. When this suit was being filed under Order 1, Rule 8, so the notice has to be served to all the parties under the representative quasi as required under Order 1, Rule 8, and that compliance is to be recorded here. Well, I don't think that compliance has been done, because that compliance has to be recorded by this honorable court, suit court, and only thereafter proceeding can start after noting it that the Order 1, Rule 8 has been complied with, because all those who 3,800 members who are not parties to the proceeding will be bound by the order. If there is no proper notice to them, in that case, my lord, the proceedings becomes bad. And in this regard, I will be setting judgment that if the Order 1, Rule 8 is not complied with meticulously, then the proceedings become bad, and then some person needs to be transposed or suit may be dismissed. My lord, the third point is this, my lord, that entire matter is in the realm of the contractual bylaws. If there is a breach of that, my lord, then it will be the contract law applies, breach, damages, and if the specific relief act applies, in that case some orders under the specific relief act can be passed. Section 14 is the section which guides that in such matter what order can be passed. I will be citing one compilation of judgment where it says that in such type of a club matters, there is no application of section 14 of this act release and the suit would not be maintainable. Then, my lord, my third point was this, my lord, that what he was being demanded was being restoration of his membership. That is because after suspension, revocation proceeding is not under challenge, and that having not been under challenge, nothing survives in the suit. So now, my lord, with this, these are the short points of my case, and in support of that, my lord, just But if my lord, we kindly see this page 5 of this is a Bombay High Court judgment, my lord.
Yes.
I will be very fast, my lord. The paragraph 23, this termination of membership, if at all argued to be contrary to the principles of natural justice, as understood in common parlance, even in such an eventuality, action of the respondent may amount to a breach of a term of a stipulation of the contract, memorandum of association, and hence said breach cannot be remedied by injunction, though it is a entity juristic person. The nature of relief of enforcement of a contractual obligation which is to be performed by a group of individuals. Association is a contract of personal relationship and of a personal service, and it cannot be enforced by a decree of civil court. Last submission is that allegation made by the plaintiff are not proved by legal evidences, etc. Then I am not reading the paragraph 25. The court has to bear in mind a fact that a membership of any social club association is often a matter of honor than a right. When it comes to need for good etiquette and good behavior, law has its limited role. I am on paragraph 26, my lord. The conduct of the parties to a private contract cannot be supervised on day-to-day basis, even on the ground a decree of specific performance would not be ordered by the court. Therefore, plaintiff's claim is of such a nature that though declaration that termination may eventually be found to be contrary to the principles of natural justice, yet a decree of injunction cannot be granted, since observation of the principles of natural justice is neither condition prescribed by any law nor is provided by the contract between the parties. In a given situation, in absence of plaintiff succeeding in showing before the trial court or this court any statutory obligation enforceable as the contract or a law, a decree of injunction cannot be passed in view of the embargo which emerges from the collective reading of 14(1)(c) and E of the Specific Relief Act. But what I was arguing was this, my lord. If the members do not want the persons to be with them, then this court can't impose that you do fellowship with them. So this is not something which the court can enforce. And if there is a breach, then one can claim damages or can go into the Specific Relief Act. In this suit, there is no question on reasonableness of rules.
Yes.
There is no question. Rules, and they can't even question that the rules are not reasonable. If the reasonableness of rules are not subject to judicial scrutiny of the civil court, and there is no challenge, breach is also not the challenge. Challenge was breach of natural justice that has been addressed, so nothing survives in the suit, and order 1 Rule 8 principles not followed this. So my lord, this judgment is being followed by Division Bench of Delhi High Court, which my lord will get at page 23. My lord, this judgment at page 23 starts at page 7, but I straight come to the page 23, paragraph 67.
Yes.
Malhar has got that. But in our opinion, learned single judge rightly observed. Furthermore, even if we assume for the sake of argument that the contract of grant of privilege of use of the club under the concept of green card holder right exists between the plaintiff and the club, this contract is terminable in nature and cannot be specifically enforced. According to section 14D, Specific Act contracts a determinable nature and cannot be specifically enforced. Additionally, 41E of the Specific Relief Act prohibits the granting for an injunction to prevent the termination of such contract. This legal principle has been affirmed in cases Ram Swarup Sundar Lal Goyal versus North India Association, where it was held that the conduct of private contracts, such as club membership, cannot be supervised by courts on day-to-day basis, thus cannot be enforced through injunctive relief. In light of the above, plaintiff cannot claim enforceable membership right under AOA or company law. Additionally, the club as a private entity retains the prerogative admission and usage of the facilities, limiting membership as it deems fit. Membership or usage of the club facilities cannot be claimed as a matter of right, etc. This is what is submitting. Now, the second point which I was arguing was this, that now the very concept of this suit under Order 1 Rule 8 says that the notice, I don't think Malana will clarify whether the notice was issued by this court. By then they can explain it. And we have written letters to them. Please tell us and which newspaper, etc. this has been done. There is no answer by them, my lord. If my lord, kindly come to the page 91.
Yes.
This is a judgment of Orissa High Court and page 94. I have got that page, paragraph 6. There cannot be any manner of dispute that when suit is filed invoking the provisions under Order 1 Rule 8 of the Code of Civil Procedure, the said provision must be fully complied with. In view of the contentions raised by the learned counsel, the appellant, I carefully examined the order sheet of the lower court and find sufficient force in the contents of the learned counsel. On examining the order sheet as well as record of the case, I find that by Order 9, the court has directed for publication of the notice in Weekly Nabina, but there has been no material thereafter either in the order sheet or in the record to indicate that such notice had in fact been published. Since the notice has not at all been published, question of further finding out whether there has been due compliance of the provisions of Order 1 Rule 8 of the Code of Civil Procedure cannot be gone into. In absence of any material that notice was published as directed by the learned judge, there is no other option but to hold the overnight is not complied with, and consequently subsequent proceedings including disposal of suit be held bad in law, etc. So this exactly, my lord, Allahabad High Court has also said same thing. That is as page 71, page 77, and at the page 99, operative parts, that is 7, paragraph 7 of that judgment at page 99.
Yes.
Is the paragraph. No, it just says that. So I just maybe 6-7 lines are there. It is well settled that omission to comply with the provisions of Order 1 Rule 8 is not a mere irregularity, but goes to the root of the matter. And if the compliance of those provisions has not been made, decree could not be deemed to have been passed in the capacity. In the instant case, trial court before whom the application was made passed no order granting or refusing permission to plaintiff to sue in the representative capacity. Notice was published in this newspaper was not a notice or institution of suit, but a notice for filing an application under Order 1 Rule 8. Even after the date mentioned the notice, no order granting, refusing permission, etc. was granted. And this, and the same is being taken. So I don't need that. I should place that entire one, my lord. So, my lord, after this, my lord, my point is this, that on which these judgments are already being there, that in a matter where the service law is involved,
Yes.
there cannot be a enforcement of that, and there cannot be a suit, my lord. That, my lord, that judgment is there, my lord. If my lord kindly come to the Supreme Court judgment at page 28, my lord.
Yes.
At it starts at, my lord, this the 3 years has been judgment at page 41, paragraph 18.
Yes.
On a consideration of the authorities mentioned above, it is therefore clear that a contract of personal service cannot be ordinarily enforced, and the court normally would not give a declaration that the contract subsists, and the employee, even after having been removed from the service, can be deemed to be in service against the will and consent of the employer. The rule is, however, subject to the 3 well-recognized exceptions. My lord, these are the public law elements, which is under a government servant, etc.
Yes.
My lord, here also there is no public law involved. Company law, corporate law, statutory law, all law. So this is also not applicable, my lord. So my these are the sum and this of my that the entire cause of action which they came to this court was that suspension was without notice. Now that chapter is over. So cause notice is issued in 12th April after the suit and after my lord's order. This is a subsequent event. My lord's judgment, it was in March, 20th March 25. Thereafter, we proceeded and
Acha, we got okay.
yes, judges. After that, we gave a so cause notice. That was a substantive so cause notice, a substantive proceeding which was not covered in the suit, which was born later. When it was born,
That is after the division bench order or after the
and after in between. But that April 25 so cause notice was settled by the division bench order, which says that you continue with the adjudication proceeding by the SGM.
Yes. Yes.
There is no grievance that any breach of natural justice has been caused after so cause notice. Entire argument of my learned friend Mr. Chaudhary was before suspension. That period is over. That is over now. वो चला गया.
They are not with regard to this second notice which has been.
No, what I'm saying is the breach of natural justice before.
Breach of natural justice.
But that is over now. After the so cause notice, all these chapters are over. New chapters begin. That cause of action no longer survive. So in this suit, post so cause notice matters cannot be proceeded with in this matter because those are independent cause of action, not something which is connected with this.
Okay.
So, my lord, this is an action which they have referred to in a division bench after the so cause notice. That was for revocation. Revocation is not subject matter of this, and so cause notice was not under challenge, not here also. No further place. They received the so cause notice. They appealed to the division bench. They moved again. So cause notice was not under challenge.
Yes.
If the so cause is not under challenge, then nothing is under challenge. Then adjudicating authority is already named, and no other person can do it. So, my lord, there is no case at all. But only I close it with this. Sometime when we do not express this, when I heard all the time, this minute was not given, etc. Those were all pre-suspension and pre-stage, my lord. As I was noting down something, my lord, this 3 lines in Urdu, I say subject to your lordship's permission. अगर कुछ भी गिला ना हो तो गुजरे हुए जमाने से शिकायत तो कर ही सकते हैं. अगर शराब नहीं है तो बड़े ग्लास तो दे ही सकते हैं. दिया बुझ गया तेल न था सर्द हवाओं से गिला कर ही सकते हैं. But these are my closing submissions.
Thank you.
Your Lordship.
Now I remember the Justice Khadju.
Let me go by chronologically. Firstly,
Always it starts from there. Even if the court sits and he starts from that phrase only.
there are 3-4 points raised by Mr. Mitro. So I'll just give chronologically answers.
Thank you.
First, Mr. Mitro has tried to correlate some other suit filed by one Sardar Shamim Imam. Your Lordship, Mr. Imam is also an advocate. He has nothing to do with my client. My client has no role in that suit. Mr. Imam has appeared for candidature in the AGM. He found some irregularities. He went to court. It's just that the father of the plaintiff, the father-in-law of the plaintiff has proposed him. In fact, the plaintiff's son was also there as a candidate. Had the plaintiff any motive, then he would have asked his son to file the suit. So plaintiff is no way connected. That is one. And merely because one of the junior counsels here, Mr. Dinda, has appeared in the suit and he has appeared in that suit, being a member of the bar, so everything is correlated, everything is done by the plaintiff. That's what Mr. Mitra said. Second, the report of Khattar, the CA, is of 1st October. Your Lordship, if your Lordship may kindly take that AGM, which the AGM noticed once at 209. The AGM notice is of 12th September at 209, where they say that to consider transact the business, that the agenda number 5, which they said it's there in the previous meeting also, the previous notices of the previous AGM said, even during the tenure of the when the plaintiff was the president. But one thing was introduced which was not there. This is for the first time in violation of Rule 49. That is the part at the bottom to facilitate the adequate replies. Even the bracket one, that on or before 20th September, and then the bold one, the asterisk, to facilitate adequate replies to members' queries. Only queries received before 20th September will be entertained or replied to. No other questions, discussions, resolution may take place. This was never introduced. It is in violation of Rule 49. Rule 49 provides for all these discussions to be held at the AGM. If a lordship sees that previous notice, this part is not there. This was introduced by them. So they had given a deadline.
So whether within the rules or bylaws, is there any format of the notice?
No, there's no format of the notice.
No format.
But Rule 49 says that all account relating questions to be raised in AGM.
Correct.
Here they are binding it that by 20th you give your queries, else you will not be entertained on the AGM. And second,
That's why maybe they have put some condition because on the last 19th hour you come with the document.
in 7 days, when these notices are coming, forwarding the accounts, not everyone is an accountant that who will glance through. Like a layman cannot just glance through a plaint or a petition and come to a brief synopsis of the case. Rule 49 shows.
But if it is take otherwise, after that notice you appeared and you are not stated that you are not given a proper opportunity to give.
Appeared where?
You appeared in the AGM.
Yes, and those answers, those questions, queries were
You have
answered.
raised the 3 questions.
Yes.
Before that, you have given the
Even in the
before
AGM,
this WhatsApp messages, you have given 3 questions that has been decided in the taken into consideration in the
AGM.
meeting. Now you are raising with regard to this last portion of the bold portion. But
yes.
you have whether you
Because-
have given any reply to this, only 7 days is not required. You required further time.
No, that was not done.
Okay.
In the previous year's AGM.
In the previous year's AGM, it was done,
Pointer.
which we have prior to in June also. We have raised that we have not yet got the answers to the previous queries raised at the previous.
Now under this challenge, so you have attended the meeting, you have raised 3 questions and you have issued the letter prior to that, and that has been taken into consideration in the AGM. So whether you have issued any notice, sir, you have given only 7 days time, so I may
No, even in the AGM notices to the queries, the chairman said that we will get back to you. Till date, he has not get back.
Okay.
That is there in the minutes.
Okay.
To the queries that how these accounting entries are classified as regrouped, because once in an AGM the accounts are finalized.
Yes.
So if the figures which are finalized in the year ending 31st March 2024
Yes.
cannot have changed
Yes.
on the next year,
Yes.
because those figures are finalized. So they say we have reclassified,
Okay.
but merely because reclassified you cannot change the figures.
Okay.
That was one.
And what would be the
Huh.
answer? What would be answer to the Khotar? What is the your chartered accountant? The last observation of your
Your Lordship,
accountant?
a detailed report we sought for because we have raised those questions. By 20th, it was 7 days. He has just indicated which I have raised on my 20th and 23rd.
No, not that.
Yes, that the disclaimer.
Disclaimer.
That is only the disclaimer. I am supporting this report is only in support of the disputes which has been raised by me.
Correct.
Obviously, it won't be taken consideration, but the club auditor has also not come up with any answer, or the club has not come up with any answer. No, whatever the queries have been raised by you or this report, everything is rubbish. In fact, they admit in the AGM that yes, there are anomalies, they have been reclassified.
Yes.
So my allegations with regard to the accounting entries, that has not been denied.
Okay.
Thirdly, your lordship, as Mr. Chaudhary has pointed out, that annexure II, the 29th January, in all affidavits, first of all, none of the other respondents have filed any affidavit, save and except respondent number 1 for Mr. Mitra, who is appeared. The secretary, rather, respondent number 2. Even Mr. Mitra, during his arguments, nor any of the other respondents have addressed on this issue as to whether annexure II was taken consideration while passing of the suspension notice on 30th. It was completely silent during their argument. So I take it they had no answer to that and it was not considered. Now, I come to
What is the
Mr.
date of the notice?
29 January.
Yes.
And in our
GA1.
And in our GA1, we have explained that last year's AGM, the questions raised has not been replied.
This is a question, time question.
And that the 12th September, we have got this agenda, the notices that has been dealt in paragraph 26 of our petition. Now, another thing was also addressed that in the appeal, GA2 was not pressed. We tried to stall the AGM, which appeal court has not entertained. Kindly ask them to show the prayers of that. That was while the appeal court was hearing, appeal court has passed an order that don't hold the special vote till appeal is pending. No, in GA2, I prayed for during this pendency, subject to the result of the appeal, allow me to participate as a candidate, which appeal court was not inclined, so we have not pressed. There was no stay of AGM which has been sought for. So I never asked for stay of the AGM. And that I have suppressed GA4, which is an amendment application. Your Lordship knows amendment is my right. After filing of the suit, which was filed in a haste because I was suspended, subsequently we found that this Rule 22 itself could have been challenged and should have been included in the plaint. Otherwise, if any order we are seeking may be outside the scope of the plaint. That's why we have filed an application for amendment and an affidavit direction is has been given on 20th July, I believe. So as and when that application comes up, your Lordship will consider. There's nothing of suppressing any application.
Okay.
This is with regard to what Mr. Mitra has submitted. Now, what Mr. Bhattacharya said, the conduct of the litigation. He first has relied on this judgment of 2020, volume 2, SCC 52, paragraph 17 of K.D. Sharma. That I have suppressed.
Yes.
With all due respect, at the final hearing,
Yes.
none of the documents before you have been suppressed or they have produced any document which I have been suppressed. Yes, I admit that at the time of filing of the petition, that 20th September notice was by mistake or since the petition was filed in haste, could not have been included. But subsequently in reply, I have disclosed it and everything is before your Lordship. So nothing has been suppressed. So he cannot say that I have come with a unclean hands.
No, that's why that document is taken into consideration by the division bench.
Because
on
at
the basis of this, Mr.
Right.
Bhattacharya.
Now, while passing the division bench in both occasions, division bench was aware that this document is misplaced. We ought to have disclosed it. We have lost. But even then, division bench being conscious of the fact had allowed us that GA1 should be heard. Their views are prima facie views. Even on the second day, they say, I have entered into a contract, given a consent order, everything was done. Even then, division bench being conscious of the fact, extended the time for filing of time for affidavits in GA1. Division bench, if that is so, division bench has disposed of GA3, then division bench would have also disposed of GA1 also, that nothing remains in the suit or the GA1 I am disposing because you have given consent for the special board. Division bench being conscious of that fact, allowed us, said you file your affidavits, the matter is being heard after 2 weeks. If you get the matter to be heard out in the meantime, that's it. Otherwise, you participate in the special board. The results of the suit will abide by it.
That's why nowadays the division bench normally is not entering into the merit of if the ad interim is rejected, division bench directing the prior court or the single bench to let you go and file and decide on merit. But yeah, I don't know. Yes.
Lordship. Now, then what Mr. Dashgupta has relied upon, quite a few judgments. Most of them are with regard to club elections. I'm not bothering your Lordship, but I'll just rely on one judgment which is in my favor.
Which one?
The Lodge Victoria. Paragraph 8, 1962, SCC Online, SC 47. He has read a portion of that paragraph.
Logical, yes.
The following principles may be gathered from the above discussion.
Paragraph
8. He relied on paragraph 8, but he relied on a portion of paragraph 8. I am relying on the entirety.
Yes.
The following principles may be gathered from the above discussion. 1. A member of a Masonic lodge is bound to abide by the rules of the lodge, and if the rules provide for expulsion, he shall be expelled only in the manner provided by the rules. So I am also saying the same thing. If I am to be expelled under the rules should have also been followed by the club. The club cannot do high-handedness or change the rules or take decisions, whatever suits them, against the rules. The lodge is bound to act strictly according to the rules. Whether a particular rule is mandatory directly falls to be decided in each case, having regard to the well-settled rules of the construction in that. I am also agree with your lordship. That's the settled principle. Third, the jurisdiction of a civil court is rather limited. It cannot obviously sit as a court of appeal from decision of such a body. It can set aside the order of such a body if the said body acts without jurisdiction. As Mr. Chaudhary pointed out, MRC never had the jurisdiction at the first place, or not act in good faith, acts in violation of the principles of natural justice, which is our case from the day one, that whatever action has been taken is in violation of the principle of natural. And whatever division bench has said, that is all prima facie view. So it cannot be taken into consideration. Division bench has also settled this issue. Lastly, Order 1, Rule 8, your lordship, newspaper has been published in both English and Bengali. Both has been published, it has been complied with. Now the Order 1, Rule 8, those rest of it is with when the suit is being about to be processed. Today we are on GA1's hearing. It is not that Order 1, Rule 8, he shared that he has given us some notice. I asked for it, then he was silent about it. We have not received any notice asking as to when you have made the newspaper publication. And lastly, and though most of the judgments which this heavy compilation is on the Order 1, Rule 8 only. And lastly, my learned friend has admitted that they had not given any show cause notice. They have suspended without the show cause notice. And it is his understanding or his client's understanding, who is the committee member, that the show cause notice was given after your lordship's order of March. So they are trying to rectify the mistakes.
No, admittedly there was no show
No,
cause
no show cause notice.
This court has also given whatever it may be, but and they admitted even immediately after my order, before your appeal, they issued the show cause notice that the matter was taken into subsequent all the things that happened.
So the very root, the inception, the action from 20th September from the AGM, the steps from the meeting which we don't have a copy, but your lordship was discussing when Mr. Mitra
pointed out 28/9 and 23/10. Our names are mentioned, so they are aware.
Like they were aware that Mr. Surana has issued the notice. That's why they have also issued the notice to Mr. Surana. He says that no membership number was given. Mr. Surana never denied, and I don't think there is any other Jai Surana in the club. So they issued the notice directly to Mr. Surana. So they knew that he had issued it, and they continued asking, "Have you written it? Have you written it? Have you issued this WhatsApp?" That was the only thing. And from the transcript, it was evident they were supposed to give minutes. They were supposed to give questions. The questions to be coming from the executive committee. Nothing of that sort. Okay. Those are my submissions. If your lordship allow us, then we can file a 2-page note by Monday.
Thank you.
Maybe take the
from us, or if your lordship wants, we'll prepare a list of dates.
By Monday.
By Monday. Monday morning.
Meeting is over.
No, it's still continuing.
What I propose, let you continue to complete your meeting. I am fixing till 8. You not to give any effect to that whatever it is, and I will dispose.
The lordship will not pass any order. We will not do anything.
Lordship will record their statement.
Any order can be misinterpreted.
No, why?
So, my lord, on understanding, my lord, we will not pass any order. Nothing will be published till your lordship's order is passed.
Okay. Lordship, may I take back those newspapers, your lordship?
Huh?
Or if your lordship wants, we can give a photocopy of. Today only in half an hour we'll give.
No, along with the notes, you will.
In the notes,
nothing will be published till your lordship's order comes up.
So I am not recording. The hearing concluded in connection with GA1 of 2025 or 24.
A lordship may kindly, because they may say misinterpret also, because that court has not passed anything or court has not.
This court hope and trust that till this order is passed, the committee and the meeting and no No
the special
publication,
board.
no publication will be made in the decision taken by the special,
Lord.
in the special meeting held on
Held
Second-
Held
August
today, held today, held
second.
Is that okay?
deeply obliged, and thank you for the, we are grateful for
Well, not thank you. Saturday we had to come.
No, even my lord has come to, because we have enjoyed this holiday during Rath Yatra.
My lord, your lordship
But we are
has to
grateful
come.
that lordship has given this patience here.
Your lordship has to, just as yesterday, my lord, Justice Banerjee's court, my next door, we were discussing about today. So Justice Banerjee said, switch off the video, and then he said, I do not approve of Saturday.
My lord, I don't think the video is off right now.
I can say I have, I have no problem.
Whatever it happens.
না না আবার করবি হয়ে গেছে না আর হবে না। আজকে not to pass adverse order.
That can be allowed, will allow the language will be sued.
Which item number?
97. GA1 has been for Millet extension.
They filed the written
They
statement.
filed. We have been served.
97 Gopal. Thank you. Thank you.
Deeply.